So we're recording. Okay. Name and badge number for the record, please.
Corporal Zeno Badge 210 with the Detroit Police Department Investigation Operations Unit Court Officer.
Thank you. In your submissions today, will you be testifying from investigators' reports?
Yes, ma'am.
All right. Please raise your right hand. Swear from the contents of those reports are true to the best of your information and belief.
I do.
Thank you. Hold on one second. Okay, there we go. All right, let's begin with People versus Anthony Valentine, please. I've got one count of carrying concealed weapon. Go ahead with your testimony.
Okay. On January the 15th, 2023, the defendant Anthony Valentine was arrested for carrying a concealed weapon in a motor vehicle. The recovered firearm, an unknown make, model 9mm handgun, was loaded with multiple live 9mm rounds and a seated extended magazine. No round chambers. No serial number was observed on the firearm. Per lien, the defendant does not possess a valid concealed pistol license. On January the 15th, 2023, at approximately 12:30 a.m., Detroit Police Scout 437, manned by Officer Benavides and Harvey, on routine patrol in the area of I-94 and Martin Street, located in the city of Detroit, county of Wayne, Michigan. At this time, Officer Benavides observed a red 2015 Chevy Malibu bearing Michigan plate Edward King Williams 5810 traveling northbound on Martin Street. Officer Harvey entered the vehicle's plate into lien and observed the vehicle to be uninsured. A traffic stop was initiated for the said observation. The vehicle was occupied by 3 adult occupants and a newborn child. Officer Benavides made contact with the driver, defendant Anthony Valentine, advising him for the reason for the stop. Defendant Valentine failed to produce a driver's license, registration, and proof of insurance upon request. Officer Benavides inquired if the defendant possessed a CPS, to which he replied he does not. Defendant Valentine was asked to exit the vehicle, to which he complied, giving Officer Benavides consent to search the vehicle. Officer Benavides placed the defendant in handcuffs without force or resistance, pending further investigation. Officer Harvey had made contact with the front seat passenger, Mr. Ferris Dixon, who was also asked to exit the vehicle, to which he complied. A rear seat passenger, Iris Vargas, was also asked to exit the vehicle, to which she complied. Once all persons were out of the vehicle, Officer Benavides began to search the Chevy Malibu. Officer Benavides opened a diaper bag on the rear seat and observed a handgun. Officer Benavides then returned to the occupants and inquired who the baby inside the vehicle belonged to. Defendant Valentine and Ms. Vargas both replied, "Both of us." Officer Benavides asked Ms. Vargas if she possessed a CPS, to which she replied, "No." Officer Benavides placed Ms. Valentine in handcuffs pending further investigation. At this time, defendant Valentine made an excited utterance, "Whatever guns are in there are mine."
Okay, let's stop there. He didn't have a CPL, is that correct?
Yes.
Okay, thank you. I do find probable cause, signing, sitting on for processing. Let's go next to People versus Malcolm Hatchett. Again, one count of carrying concealed weapon. Go ahead with your testimony, please. You're still sworn.
Okay. On Saturday, January the 14th, 2023, at approximately 16:50 hours, police officer Marchand and Cadez and Corporal Bronham were in the area of Shaner and East 7 Mile Road. Officer Marchand stated in his report he observed a gold 2013 Chevy Malibu bearing Michigan license plate Edward Henry Davis 0710 with dark tinted front windows traveling northbound of Shaner approaching East 7 Mile Road. Officer Marchand observed the vehicle pulled into the parking lot of 1354 East 7 Mile Road. Per lien, Michigan license plate Edward David Henry 0710 is improper and registered to a 2003 GMC. Officers initiated traffic stop and made contact with the driver. Defendant Corporal Bronham asked for defendant's driver's license and paperwork for the vehicle. The defendant said he did not have a driver's license and CPL. Bronham asked the defendant if he was going to have.
That's sufficient. Thank you. I do find probable cause, signing, sitting on for processing. Let's go on to People versus Otis Rucker. We've got one count of CCW here. You're still sworn. Please proceed.
Okay. On January the 14th, 2023 at approximately 9:45 p.m. Police officer Vortex and his partner McGregor and Holmes were giving special attention to 10601 East Otter Drive, Detroit, Michigan. A Detroit Police green light partner when Officer Bortez entered the location, observed Otis Rucker, the defendant, standing at the counter. Officer Bortez further observed the defendant have a heavy weighted object in his front left jacket pocket, which he had the imprint of a handgun. Officer Bortez then asked the defendant if he had a concealed pistol license. The defendant responded by saying no and attempted to leave the business. Officer Bortez then asked the defendant to stop. He complied. Officer Bortez recovered a .380 handgun from the defendant's front left jacket pocket where the imprint was observed. Per the law enforcement network check, the defendant does not have a concealed pistol license.
Great, thank you. I do find probable cause to support the charge. Signing, sitting up for processing. Talk to you later.
Thank you.
Bye-bye.
Bye-bye. Three, 1, 3, 5, 7, 4.
Detective Jackson.
Three, 1, 3, 5, 6.
I got
Uh-huh.
try 596
Uh-huh.
2555.
Okay, thank you. For Detective Jackson?
Yes.
Thank you. You said 2.
596 2555.
Yeah, not answering there either. Okay.
Did I put 574 2291?
Yep, tried that one. That's my straight to
Detroit
voicemail.
Police Commercial Auto Theft.
Hello, I'm trying to reach Detective Jackson. This is Magistrate Ramsey Heath.
Yes, ma'am. Hold on 1 second.
Oh, boy.
Hello, ma'am.
Yes.
Okay, hold 1 second. Here's Detective Jackson.
Thank you.
Good morning, Your Honor.
Good morning. How are you today?
I'm fine. I apologize for not answering the call, but I was on another call.
That's
The
okay.
phone has been ringing all morning.
No problem. It's like search warrant day for me. It's hard sometimes to keep up.
Yeah, you're probably going to get another one.
Yeah. All right. Okay. So this one is People versus Sean Darnell Tyler Jr. Name and badge number for the record, please.
I am Detective Louis C. Jackson Jr., badge number D4000 of the Detroit Police Department Commercial Auto Theft Unit.
Thank you. Are you going to testify today from personal knowledge or investigator's report?
From an investigator's report that was prepared by Police Officer Jacob Hebner, badge number 4218 of the Detroit Police Department Commercial Auto Theft Section.
Thank you. Please raise your right hand. Swear or affirm the contents of that report are true to the best of your information and belief.
I do.
Thank you. Go ahead with your testimony here, please. I've got one count of assaulting, resisting, obstructing police officer.
Yes, ma'am. The vehicle in question, ma'am, is a 2016 gray Chrysler 300 with the VIN number being 2 Charles, 3 Charles Charles, Adam Boyd George, 5 George Henry, 259028. Kelly Blue Book value of $17,094. Circumstances on November the 20th, 2022, Mr. Dion Cummings contacted the Farmington Hills Police Department to report an auto theft. Officer Ross of the Farmington Hills Police responded to 37091 Jefferson Court and spoke with Mr. Cummings, who stated that on November the 18th around 8 o'clock a.m., he had parked his gray 2016 Chrysler 300 with the VIN number that I just gave you, ended in George Henry 2955028, with the license plate being David Paul Williams, 1863, in the parking lot of the apartment structure. And upon returning November 20th, he discovered his vehicle was no longer at the location and it had been stolen. Officer Ross completed the report 22-38103 regarding the incident and entered the vehicle into the law enforcement information network as stolen. On January the 13th, 2023, Officer Kyle Presley was working Scout 9 Motor 3 in a marked vehicle wearing a department-approved uniform. Officer Presley was in the area of Tacoma and Gratiot around 1500 hours when he observed the gray Chrysler 300 with a temporary plate driving at a high rate of speed. Officer Presley observed the vehicle come to a stop on the southeast corner of Hoyt and East State Fair, and the driver exited the vehicle. Officer Presley approached and initiated the traffic stop on the vehicle and driver. Officer Presley identified the driver as Mr. Sean Taylor by state identification provided by Mr. Taylor. Mr. Taylor stated that the temporary license plate on the vehicle did not belong to the Chrysler, so Officer Presley copied the vehicle's VIN, ended in George Henry 259028, to check in lien. After checking the VIN in lien, Officer Presley discovered that the vehicle had been reported stolen out of Farmington Hills. Officer Presley exited his patrol vehicle and approached Mr. Taylor, who was standing on the street. Officer Presley requested that Mr. Taylor turn around and place his hands behind his back. Mr. Taylor then fled the location on foot. Officer Presley pursued, giving verbal commands for Mr. Taylor to stop. Mr. Taylor circled a few houses and began to run back to where the traffic stop had occurred. Mr. Taylor re-entered the stolen Chrysler and attempted to flee the location in the vehicle, but had not been removed from the vehicle prior to Officer Presley. Mr. Taylor was arrested for possession of a stolen motor vehicle, as well as resisting and obstructing the police, and was transported to Detroit Detention Center without incident. Investigation. Officer Hefner was assigned this case for investigation on January the 14th. Officer Hefner reviewed the arrest report and body cameras of the incident. Officer Hefner contacted Farmington Hills Police and obtained a copy of the original theft report. Officer Hefner spoke to Mr. Cunningham, who confirmed that he did not give anybody permission to take and use his vehicle, but the hearsay form was completed regarding the conversation. All video was uploaded to the evidence.com. Missions and confessions on January 14th, 2023. Officer Gregory Finnick of Detroit Police Commercial Auto Theft Section went to the Detroit Detention Center to conduct an interrogation of Mr. Taylor after being informed of his constitutional rights. Of his right. Mr. Taylor stated that he knew that the vehicle was stolen and he tried to run away from the officer. That is it, man.
Thank you. I do find probable cause to support the charge, signing and sitting on for processing. Let me just ask you, is there any assaultive history here that you think I need to be aware of when setting bond?
Ma'am, I'm looking at it. It is CCH?
Yes.
No, it does not have anything with that. No, it does not.
Okay, very good. Thank you very much.
You're welcome.
Talk to you later.
Bye-bye.
Bye-bye.
Did you scan it?
That one I don't know about yet.
Board Investigator Sanders.
Hey, Sanders, Ramsey Heath, how you doing?
I'm fine, ma'am, and yourself?
I'm great, thank you. Okay, you got a couple of doozies today.
Let's see if we can work through these quickly.
Okay, all right. Name and badge number for the record, please.
Investigator Brian Sanders, badge I-219, Detroit Police Department Court Officer.
Thank you. Are you testifying from investigators' reports today?
That is correct.
Thank you. Please raise your right hand. Swear from the contents of the reports are true to the best of your information and belief.
I do, Your Honor.
Thank you. Who do you want to start with?
Let's do Thurman.
Okay, People versus Bradley Thurman. I have 1, 2, 3, 4 counts of armed robbery, each with respect to a different complainant. 1 count of discharge of a firearm in or at a building, and then 1, 2, 3, 4, 5 counts of felony firearm going along with the armed robberies and the discharge. Go ahead with your testimony, please.
Yes, in this matter, I'll be testifying from the investigator's report prepared by Detective Raymond Zilkowski of the 11th Precinct. Notice to the court, Your Honor, Mr. Thurman has a homicide warrant that was also being presented for him, so this would be a different warrant.
Okay, so we've got a homicide warrant coming.
Yes, that's the reason why he was arrested. I was on the homicide warrant.
Okay,
So
thank you.
I'm sorry. On December 29th, 2022, Mark police scout car was given the code 11-1 man by officers Dowd and Mosley. Responded to the call of service for armed robbery 401 East 7 Mile Road in the city of Detroit. Officers spoke with complainant Precious Burnside, who showed officers a spent handgun casing on the floor near the front door. Complainant Precious Burnside then stated a black male, later identified as defendant Bradley Thurman, came into the store wearing all black, armed with a black and silver handgun in his right hand. Complainant Precious Burnside then informed officers that he had the gun near his stomach and the barrel pointed to the ground, demanding money from the cash register. Complainant Precious Burnside told officers Bradley Thurman she needed her manager to open the register, and the male stated, "Quit playing with me," and she stated she was not, and called for her manager, complainant complainant Precious Burnside stated that she had about $130 in her register that was given to defendant Bradley Thurman. Page 2. Complainant Christopher Richardson informed officers that he was in the back office of the store when he heard himself being called to the front register. Complainant Richard got to the front register and saw defendant Bradley Thurman demanding complainant Sharniqua Eisenhard to put the money into a bag and to give it to him. Defendant Bradley Thurman then demanded that the complainant Christopher Richard open the register he was at and give him the money from it. Complainant Christopher Richard then stated defendant Bradley Thurman asked if he had something to say, and complainant Christopher Richard said that have a nice day. And then defendant Bradley fired the gunshot and ran out of the store. Ebony Foster informed officers that she saw defendant Bradley Thurman with the gun in his hand and that it was silver and black, enter the store and demand money from the complainant. Complainant Foster was trying to open the register she was at and began to freeze when defendant Bradley Thurman stated, "Bitch, you want me to blow your face off?" Complainant Foster stated while she was opening the register, she was pushing the silent alarm button for help. Complainant Foster stated after she opened the register, complainant Eisenhard began to put money into the bag as she was putting coin rolls onto the bag. Defendant Bradley stated, "Bitch, I don't need to change." Complaining Foster then stated defendant Thurman began to exit the store, stopping by the front door and stating, "You are trying to get shot." Thurman fired the gun before he ran out the front door. Agent Hart stated she saw Thurman armed with a silver and black gun walk up to her register, point the gun at her, and complainant Foster demanded money. Bitch, don't put no diet packs in it because I will come back and kill y'all. Complainant Agent Hart stated she went to hand him the money from her till defendant Bradley Thurman told her to put it into a bag. Complainant Agent Hart placed the money into the bag and went to place the change into the bag as well when Thurman told her, "Bitch, I don't want no change," and she then gave him the bag of money. Agent Hart stated she had about $200 in her till that she gave Thurman. Agent Hart stated that Thurman and Richard said something to each other before Thurman fired a gunshot and left. Officer Mosley observed a black Dodge Journey sitting in the parking lot of the store running. The store employee stated the vehicle is not of any of theirs. Officer Mosley conducted a lean check and observed the vehicle to be a black 2018 Dodge Journey. Officer Mosley also observed in lean that the vehicle was reported stolen and was taken by a person matching what defendant Bradley Thurman wore during the armed robbery. Black North Face jacket with North Face emblem on the rear left shoulder of the jacket that turned out to be a homicide documented under a different police report. On January 13th, Elvin Curtis conducted the arrest of Thurman for homicide case and transported him to the Detroit Detention Center. Next page. On January 14th, Sergeant Dowdy, who is part of the homicide unit, informed Officer Zelkowski that Thurman was arrested in relationship to homicide documented on report 22-12-28-0309. Sergeant Dowdy stated defendant Bradley admitted to completing the armed robbery at 401 East 7 Mile and was interviewed at the detention center interview room. And Zelkowski reviewed the recorded interview and observed that at 10:38 a.m. defendant Thurman admitted to Detective White that he robbed the Family Dollar at 401 East 7 Mile Road to get money for gas and coupons. I don't know what that is. Defendant Thurman also admitted to attempting to sell the gun he used during the robbery, but ended up throwing the barrel away near his home and throwing the rest of the gun away somewhere on the west side of the city of Detroit.
Okay, let me ask you this.
Yes.
Is this defendant, to your knowledge, currently out on probation, parole, or bond in any other case?
I do not know that information, Your Honor. But he is again locked up for homicide.
Well, I mean, right. What I'm trying to know is whether remand is available in this case. And I can't know that with respect to these charges unless I know whether he's currently on probation, parole, or bond.
Based on the information that I have, he is not.
Okay, thank you. Okay, let's go on to People versus Van Love.
Yes, ma'am. I'm ready, Your Honor.
One moment, please.
Yes, ma'am.
All right, People versus Van Love, you are still sworn. This one, we've got one count of assault with intent to rob while armed. We've got a HAB-4 notice, super HAB notice, mandatory 25-year sentence upon conviction if defendant is convicted. Go ahead with your testimony, please.
Yes, ma'am. In this matter, I'll be testifying from the investigative report prepared by Detective Marlon Binion of the 7th Precinct. On August 16, 2022, at approximately 20:45 hours, Officers Ibrahim and Jones, both dressed in full police uniform and driving a fully marked scout car, responded to 7501 East Jefferson, located in the city of Detroit, County of Wayne, in regards to assault call for service. When Officer Ibrahim and Jones arrived at the location, they made contact with complainant Bobby Lewis Brown. Complainant stated that earlier in the day he was at the gas station located at 7255 East Jefferson drinking a beer and was approached by the defendant. Defendant told the complainant that if he did not give him any money, he would shoot the complainant. Defendant produced a handgun and pointed the handgun at the complainant. The complainant continued to sit at the gas station, and the defendant continued to approach the complainant with the handgun and threatening to shoot the complainant. Page 2. Later in the day, the complainant left the gas station and walked to his apartment, and the defendant followed him. The defendant approached the complainant from behind and stated, "Run it, bitch." The complainant told the defendant that he did not have any money, at which time the defendant struck the complainant in the left side of his mouth, on the back and front of the defendant's head with the gun. After striking the complainant with the handgun, the defendant pointed the handgun at the complainant and threatened to shoot the complainant. Other citizens that were outside pleaded for the defendant to put the handgun away, which he did, and then proceeded to walk away. Officer Ibrahim ordered medics to the location. Medic 12 treated complainant for his injuries. Complainant had several teeth knocked out, a large nose, and laceration to his forehead. On August 17, 2022, Officer Binion went to the complainant's home and obtained a statement from him. The defendant stated that he knows the defendant from the neighborhood, but they are not close friends. The complainant stated he does fear for his safety and felt the defendant would have killed him. On August 17, 2022, Binion went to the complainant with Officer Mel Salskis, and Officer Messausis presented complainant with a single photo of the defendant for identification purposes. August 17, 2022, in the defendant's name in the lien, and found the defendant does not have any weapons registered to him. In the statement, Your Honor.
All right, thank you. I do find probable cause to support the charges here, which are assault with intent to rob while armed. All right, signing now, sitting on for processing. You say there may be another coming?
That would be on the other guy.
Right, I know. Yeah, I was just saying from you. From you.
We got 4 more on the table, so
Okay.
I'm sure one of them would be fine.
Okay, talk to you soon.
All right, thank you.
Mhm.
Bye-bye.
Mm-hmm. Right. All right, Madam Clerk, before I check in with the attorneys, what's our situation with respect to out counties at this point?
I'm writing them up now. I'm doing the 18th district first.
18th first. Okay.
I got 3.
Okay,
So I'm wrote up one and I'm writing up, I'm doing the second one.
okay, all right. I'll just hold off on checking with them then until I have something in my hand. Thanks.
Early.
Yep. Coke, never
Remember, we
Pepsi.
have water.
Yeah, I brought my water today actually too. So I don't get all hyped up on caffeine today. Okay.
Write something. Oh, I'm sorry. If I write something,
Uh-huh.
like I put conditions, if you cool with it, just put it in the check.
Okay.
Cause like on some of them, I heard you say the address. I mean, I heard you say the person, but I had wrote the address, but I didn't know if you wanted the address.
yeah.
'Cause I might have been doing.
Okay,
something. Just
yeah,
put a
yeah,
little check in
Yeah,
there.
I'm sure it's fine with me.
Okay.
And court speaks through its written orders, so
Yeah,
as long as
this-
it's in
this had
written
to
order.
add the address, so
Yeah,
that's
as long
fine.
as it's written, it's fine.
Okay.
Hey, Mr. Bird.
Hey, Your Honor. if, where is the New Boston? Is that Huron Township?
Who we got for New
New Boston. I
Who you
don't
got
know.
for New, Boston, Brandon? That's where I see it.
What's going on, Marcia? You all right?
Yeah, who you got for, who did I say you for New Boston?
Delana Landon.
She ain't here, Ryan.
Huron. Okay, sounds good. Thank you.
All right. I had one sitting in my drafts.
You got what?
I had one sitting in my drafts. It was Auslander. You got that? Auslander. Oh, yeah, you got it? Yeah, we sent it. Oh, yeah, I did. You just said something to me? It may have come. That's that one. Auslander.
So let me look at send. Yeah, I sent it out. Yeah, Alexis. I sent it at 47.
Okay.
So it must have been, yeah.
I don't know why I was sitting in my outbox. I mean, drafts box.
Yeah.
fix them, right?
Check the card. I'm at work too. All right, see you on the 2 at 3:30.
Thank you.
Keep hearing that ding, I keep looking up, they coming in, Jamie, they coming in on you.
You got action. That's fake action. It's just, there's no replies.
Uh-oh. Well, make sure you open them up, don't leave them.
Oh, trust me. If she email me, I'm right on top of that, Rose.
You call her Rose.
That's your boy. What she did?
So strange. We've got this guy listed as a super hab and I'm finding nothing on him in Otis. Under either of his names.
Oh, it's national or state?
It's just state, but these are state charges.
Um,
Otis will tell you if a person's been in prison, if they're currently in prison, on probation, on parole,
uh-huh.
but only if they've had a prison sentence.
Um,
But he's got a prior, maybe he got probation on an assault with intent to rob while armed. That was the prior. But also it's from 2007, so perhaps it's not updated that far back. Council, whenever you guys have a moment, let's check in about Out County.
We just have Huron left, Your Honor, and I'm waiting for them to answer the Polycom. I did speak with them on the phone and they said they were bringing somebody there momentarily.
All right, thank you. So you've gotten interviews, and can you just tell me what cities?
We got interviews in Canton, Livonia, Westland, and Dearborn.
Okay, great. Thank you. I'll get them in shortly. Hello, dear. Okay, council, we're gonna go out to Westland first. Oh, they have to call in from their iPads still?
Sounds good, yeah.
You guys have a Zoom number that you use for Westland? The last notation I have is that they have to call us from their iPads.
I could check for you. I believe they actually zoomed in to us.
Okay. All right, I'll call and just let them know they're ready. We're ready then. Thanks.
I had to make my own meeting for them to zoom in, so they don't have a Polycom.
Gotcha.
Okay.
Thank you.
You have reached Sergeant McCrae of the Westland Police Department. Sergeant McCrae.
Hello, Sergeant McCrae. This is Magistrate Ramsey Heath. How are you today?
Fine, how are you?
I'm great. We're ready for you guys to zoom into us for your arraignments.
Oh, excellent. I'll let them know. They're
Okay.
gonna, lawyers first?
I'm sorry?
What, do you have an order?
No, I don't. It doesn't matter to me, however you guys want to take them.
Okay, they're gonna see the lawyer now?
They said they've already done their interviews with the attorneys. I'll double check. The attorneys
Oh.
told me they'd been
Oh, wow.
interviewed already.
Oh, that's very fast. Okay,
Mhm.
all right, I'll let them know.
Thank you. Bye.
Thanks.
You know what he was asking me. Hmm. All right, good morning, Westland.
Good morning, Your Honor.
How are you today?
I'm fine, ma'am. How are you?
I'm good, thank you. All right, who do we have here?
This is Timothy. Oh, you want to hear from him or from me?
What's your, I'll hear from him. We'll just go ahead and get it for the record.
All
What's
right.
your name, sir?
Timothy Spencer.
Okay, thank you. And Sergeant McCray, is that you? You're gonna do the probable cause testimony?
I will.
Okay, very good. You'll just, I can't see you.
yeah.
Yeah, I can see you. Step over just a little bit. Thanks.
Yeah.
All right, go ahead and state your name and badge number for the record.
Sergeant Nathan McRae, badge 2146, Westland Police.
Thank you. And are you going to testify from personal knowledge or an investigator's report?
Personal knowledge, Your Honor.
All right, please raise your right hand, swear or affirm that everything you're going to tell me is the truth.
I do.
Thank you. Go ahead with your testimony, please. I've got 1 count of carrying concealed weapon, 1 count of assaulting, resisting, obstructing police officer, and 1 count of malicious use of telecommunication service.
Yes, ma'am. On January 14th of this year, officers were dispatched to 37765 Lakewood in the city of Westland, where the defendant, Timothy Spencer, was alleged to have threatened his girlfriend, the complainant, Elena Truitt. When officers arrived, they spoke with the complainant, who advised that she and the defendant had gotten into an argument earlier in the day. Following that argument, the defendant called the complainant, and during that conversation over the phone, he was upset and he told her, quote, "You're not going to make it home," end quote. This statement put the complainant in fear. Officers, when they arrived on scene, they observed the defendant asleep in his vehicle. He was in the driver's seat. The vehicle was running. Officers knocked on the driver's side window to wake the defendant up. Once he woke up, he put the vehicle in drive, attempted to drive away. Officers gave verbal commands to stop, announcing that they were the police. He then stopped the vehicle and put it in reverse and backed the vehicle up before coming to a stop. Officers had to position their cars in a way to block the defendant's vehicle from further movement. They then told the defendant to turn the car off, which he refused to do. They then told him to come out to step out of the vehicle, which he also refused to do. Eventually, officers were able to remove the defendant from the vehicle and then place him under arrest. Once he was out of the car, officers looked inside the vehicle. They observed the muzzle of a black handgun protruding from underneath an orange vest that the defendant had been seated on. They recovered the firearm, identified as a black Glock 19, fully loaded with 15 live rounds and 1 in the chamber. The defendant verified, and officers were able to verify via lien, that the defendant does not have a permit to carry a concealed firearm. And this defendant has no prior convictions of any criminal offense, Your Honor.
All right, thank you. Where was the vehicle when he was found in it? Was it the address where the complainant lives?
Yes, ma'am. She lives in an apartment, and he was his vehicle was in the parking lot of that apartment complex.
All right, thank you. And did anyone, I know there's something in here that says you told her to upload the text messages to evidence.com. Did anyone review any text messages?
I did not get a chance to see text messages. I was just aware of the phone call, which I think is what the prosecutor was basing the telecommunication device charge on.
Yep, so when I ask questions, sometimes I'm just asking them for purpose of setting the bond. So I do find probable cause to support the charge.
Oh, okay.
But in terms of setting the bond and restrictions that I might need to place, those kinds of things.
I got you.
But all right, so I am signing this. I do find probable cause to support the charges here. We will move on to the arraignment portion. This is People versus Timothy Spencer, Jr., counsel.
Yes, Your Honor. Brandon Bird on behalf of Timothy Spencer Jr. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Thank you, counsel. The court knows formal reading has been waived. Enters a not guilty plea on your client's behalf. Your argument as to bond.
The bond, Your Honor, my client indicates to us that he's a 21-year-old lifelong resident of Michigan, Your Honor. As far as the complaint, as far as the complaint indicates, and my client indicates to us, he has no prior criminal history, not on probation or parole, no pending cases. He is employed, but he does make less than the 200% poverty guideline, any amount of bond will be difficult for my client to pay at this time, Your Honor. He is looking forward to his day in court in this matter. I understand that one of these are assaultive allegations, but we respectfully ask this court for a personal bond.
All right, thank you, counsel. While I understand he has no prior convictions, complainant states there was a threat that she wasn't going to make it home. That sounds like a threat to kill to me. He's found sitting in the parking lot at the building where she lives, intoxicated, with a firearm that's not registered, with no CPL, with 15 live rounds in the gun and 1 in the chamber, according to the investigator's report. That concerns me for her personal safety. I am going to set a high cash bond for that reason, because I do not believe that I can keep her safe if he's out. $500,000 cash is the bond.
Hey, Your Honor, could I say something before you make that your
Mr.
I'll let your
Spencer.
attorney advise you, and then yes, if you wish to say something after that, you can.
Thank you, Your Honor. Mr. Spencer, I recommend that you only say something about your bond or your bond conditions.
Okay, that's exactly what I'm gonna do.
Okay, please don't address any facts of the case. In order to preserve your rights, you're able to fight bond at every hearing that you show up to also.
Okay. Well, I am looking forward to going to my school training I have in a couple weeks. And that's gonna, require me, if I am to complete everything, I will be required, to leave the state and take care of my business. I don't have any plans of speaking to the complainant, and I just hope that we can get the bond lower, please. I do have a lot I'm looking forward to. I have 2 puppies at home, that I love dearly. And, I live with my moms. I just had a nephew. I'm just looking forward to life. And this is the first time I'm just asking if you could take a chance on me, please. 'Cause, that's all I ask. I had it hard growing up, and this is just one, I'm just asking you to take a chance on me, please. This is me calling for a lifeline.
All right. Thank you, Mr. Spencer. I've heard your statements and you've made a record. It sounds like you have a lot of good things going on, but you've got, this one is pretty bad. And you're gonna have to see it through right now. It concerns me that there was a round chambered, ready to fire in that firearm while you were intoxicated, according to this report, while you are sitting outside of a residence where she lives, according to this report. Huron, I'm putting you in the waiting room. I'll be back with you.
I actually had an alarm set
after, according to her, having made a threat towards her. All right. So, I don't know.
I had an alarm set for.
Look, please don't go into the facts of your case and just listen to the.
No, I had an alarm set for when she got off work so I can
leave. Please don't go into the facts of the case.
Okay.
So it sounds like you were trying to tell me that you had planned to leave before she got home. I don't know, but there you were.
We can check my phone. Okay. I have an alarm set.
So, well, somebody is going to be checking. I believe somebody's going to be checking phones and text messages as this investigation goes on. And so if it all pans out the way you say it is, then hopefully justice prevails and, the right thing happens here. My job is a very short-term job. It's to keep her safe right now. You're going to have another court date on January 26th. And when you go to court on January 26th, your attorney can talk to them about the bond that I've put on you. In fact, you may have a lawyer that wants to file an emergency motion to ask for it earlier. But as for now, this is what I feel is necessary to protect her, given what I have heard happened that day.
Please take a chance on me.
$500,000 cash. You are not to purchase or possess any firearms or other dangerous weapons if you're somehow able to make that bond. You are not to have any contact with the complainant. You are not to have any contact with the complainant's address. You are not to go back there. All right. No contact means no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact will be a violation of the conditions of this bond. The next court date is January 26th at 9 a.m. After that, February 2nd at 9 a.m. I understand that this is likely to keep you in. My intent is to keep you in until the next court date, until the judge, working with more information, perhaps looking at these text messages, is able to make a more informed decision. In addition, if you are able to make the bond, you must be fitted with a GPS tether before you leave the jail.
Can we
so
agree to
that
the
we can
tether
make sure
instead of the
you guys
bond?
stay away.
Can I get the tether instead of the bond, please?
Sir, I
But I
suggest
do
that
have
you
a
take
job.
some
It's
time.
gonna
I
be-
suggest that you take some time and really think about what you're facing.
I
That's
have a
it.
job.
That's it.
was
This is
so
not
hard
a
for me to
tether
even
thing.
get this job.
When I have a report that says you threatened someone that they wouldn't make it home, that she says she has text messages to that effect. You're found outside her residence with a gun loaded, one in the chamber, intoxicated. Absolutely not. My intent is for you to stay there until you see the next judge. Bond will remain as I stated. Thank you. Huron is dialed in, so I know you've got a lot of things going on down there. They've already called into me.
We need to interview Huron. I was waiting for the officer to
Oh,
get
okay,
there.
that's what it is then. Let's get you in a breakout room. Okay, thank you.
Right.
Okay, Huron, I'm gonna send you into a breakout room so that you can meet with an attorney.
All right, thank you.
Okay.
Morning. Hi, good morning.
Your attorney, when you're done.
Are we sending him Ms. Stevens? Mr. Bird, Ms. Stevens?
Let me check, Your Honor. One moment.
I got lied. He was pretty good to not sit on concrete.
Yeah.
Lying if I said I wasn't nervous.
All right, we'll go ahead and start your probable cause testimony in Westland there. Who do we have, sir? What's your name, please?
Me? Oh, John Hooker?
Okay, thank you, Mr. Hooker. All right. And is Sergeant McCray, are you doing the testimony on this one as well?
I am, Your Honor.
All right, thank you. All right, this is People versus John Jesse Hooker. Are you testifying from personal knowledge or investigator's report on this one?
Personal knowledge.
Thank you. Please raise your right hand. Swear or affirm everything you're going to tell me is true.
I do, Your Honor.
Thank you. Mr. Hooker is charged with 1 count of domestic violence. Go ahead with your testimony, please.
Yes, ma'am. On January 13th of this year, officers responded to 35270 Glenwood in the city of Westland, trailer number 7. They were able to determine that the defendant, John Hooker, while intoxicated, had made threats to the complainant, Joey Mills, a person with whom he has an intimate dating relationship, The complainant wrote in her statement that the defendant, quote, said he was going to kill me. He tried to choke me at one point and tried to swing at me, end quote. The complainant further advised the defendant had struck her in her elbow intentionally. Struck her in her neck with his elbow, intentionally causing injury.
Thank you. What is this about attempted to try a wrestling move? Whose words were those that said he was trying a wrestling move?
Yeah, apparently, I believe the complainant used that phrase when talking with officers, but in her written statement, she said that he had deliberately threatened her and attempted to strike her. So I don't.
Okay.
The wrestling move, I think, was just her way of saying an assaultive act, not necessarily a playful.
Okay. Okay, thank you. I do find probable cause signing this for domestic violence. One moment, please, Mr. Byrd. Do we know who's going into the breakout room with Huron yet?
I will be going in the breakout room with Huron. Okay. Would it be best if we finish
yes.
the arrangements first? Because we previously tried to get into. We called into Huron earlier.
Yes.
But unfortunately they weren't available. Okay. They were busy.
Okay, Huron, we're gonna have to put you back in the waiting room for a moment. We'll be right back with you.
Okay.
Thanks. It's gonna be probably about 10-15 minutes.
Okay.
Okay, thanks. Okay, we'll move on to the arraignment portion. Let me just ask you this, officer, is there anything you think I need to be aware of in terms of prior misdemeanor convictions, criminal history, or domestic violence calls to this with respect to this complainant?
Your Honor, there is a history of calls for domestic complaints involving the defendant, but he has no history of any charges or convictions of that. The only conviction on his criminal history that comes close to a violent offense would be a possession of a knife charge. He pled guilty to that in 2011.
Okay, very good. Thank you so much. All right, People versus John Jesse Hooker, counsel.
Yes, Your Honor. Brandon Byrd on behalf of John Hooker. My client waives his right to the formal reading, was advised his constitutional rights, and will stay on mute.
Thank you, counsel. Court notes formal reading has been waived and enters a not guilty plea on your client's behalf. In terms of bond, I'm particularly interested in whether he has an alternative place to stay and what his work situation is.
He does have an alternative place to stay, Your Honor. He will be living with his parents, and currently he's seeking employment, Your Honor.
Okay. All right, Mr. Hooker, this is charged as a misdemeanor. I'm told you have no prior convictions except for a 2011 possession of a knife or anything that would be assaultive in any way. So I am going to give you a personal bond in this case, but it is a high personal bond. I'm giving you a personal bond in the amount of $100,000. That means you don't have to pay to get out of jail today. But if you violate the conditions of my bond, you may find yourself sitting in there without the ability to get out, unless you've got access to that kind of cash. Do you understand?
Yes, Your Honor.
There is to be no contact with the complainant, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact will be considered a violation of the conditions of the bond. In addition, you are to have no contact with the address where this is alleged to have happened. All right. Now I could put you on a tether to ensure that, but if I do that, they're going to send you to the Wayne County Jail for about a week while you wait on a tether. All right. I don't want to have to do that to you given the lack of prior criminal history. So I'm going to give you a personal bond and trust you to abide by these rules so that you do not get this $100,000 number attached to you as a cash bond. Okay.
Understood.
Pre-trial date, January 26th, 9 a.m. Thank you.
Understood. Thank you, Your Honor.
All right. Thanks.
Right this way. We'll get you out of here once we get that paperwork back. Okay.
Your Honor.
Mm-hmm. Yes.
Would the exam on that also be February 2nd at 9 a.m.?
Well, it's set for, because it's just a misdemeanor.
Oh, I'm sorry.
It's set for pre-trial.
I'm sorry. It's a misdemeanor. That's right.
Yep.
Thank you, Your Honor.
Uh-huh.
Morning, Mr. Scott. No, no. It's gonna be a good day. Have a seat right in that chair. You're on with the judge, so watch what you say.
All right, what's your name, sir?
Wayne Robert Scott Jr.
Both put our glasses on. Okay, Mr. Scott Jr. All right, good morning. All right, we've got people versus Robert Scott Jr. I have Wayne Robert Scott on this paperwork. Sergeant McCray, are you ready for the probable cause testimony?
I am, Your Honor.
Thank you. All right, raise your right hand, swear affirm everything you're going to tell me is true to the best of your information and belief.
I do.
Thank you. Go ahead with your testimony, please.
Thank you, Your Honor. This one's pretty straightforward. On January 14th of this year, officers were dispatched to 694 Superior Parkway in the city of Westland for a domestic disturbance. There, they determined that the defendant, Wayne Robert Scott, had been talking loudly and making threatening statements toward the complainant, Tiana Smith, with whom he had been in a brief, intimate dating relationship. He put her in fear of assault. And when the complainant walked from the location, from the residence to her car, he followed her and, quote, kept circling, talking loud and making threats, end quote. The complainant reported that the defendant additionally threatened to, quote, bust my windows out and beat my ass, end quote.
All right, thank you. I do find probable cause to support this single charge of misdemeanor domestic violence. We'll go on to the arraignment portion now. Mr. Byrd, People versus Wayne Robert Scott, counsel.
Yes, Your Honor. Brandon Byrd, on behalf of Wayne Scott, my client waives his right to the formal reading, was advised his constitutional rights and will stand mute.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf, and I'll hear your argument as to bond.
Client indicates to us that he's a 57-year-old resident here for now 8 years, Your Honor. Has children who he raised. They're all adults at this moment, Your Honor. No children in common with the complaining witness. Does indicate to us that he has a prior criminal history, but that was roughly 15 to 20 years ago. He is employed, team leader at an automotive facility, Your Honor. Indicates to us that it'd be difficult for him to pay a high monetary bond. Your Honor, I understand this is an assault of allegation. I haven't had a chance to read the report. We're not accepting any of the allegations to be true, but if I heard correctly that these were words being said at the time, which I'm not making a judge of guilt or innocence at this time. I'm not saying that is true, but he understands he's gonna have to stay away from the complaining witness. He doesn't plan on seeing the complaining witness. They don't live together, Your Honor, and they actually live in different cities. So it'd be no problem with no contact. And we respectfully ask this court for a personal bond.
Okay, what's the prior?
Mr. Scott.
Yes, sir.
What is the prior that was 15, 20 years ago?
I was money laundering. I had a white collar crime.
Okay, thank you. All right, Mr. Scott, I'm going to give you a personal bond. It is a high personal bond in the amount of $100,000. That means you don't have to pay any money to get out of jail today. But your reaction is correct. If you go around her, if you try to get to her, if you try to go where she is, you can find that number attached to you in a very different way when you're sitting back in there. Do you understand?
Yes, ma'am.
No contact means no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact with her would be considered a violation of the conditions of the bond. Same thing goes with that address where this is alleged to have occurred. Do not go there. Do not go there. All right?
Excuse me, Your Honor.
Yep.
I live there. That's my house, 694 Superior Parkway.
No, we can't go to her.
Oh.
Okay. Does she reside there?
No.
Okay, all right, then it's just, then I will take that off. It'll just be a no contact with her, okay?
Okay.
No
Uh-huh.
contact with her. What that means is if she is living there, you can't go there.
No,
But if
she'll be
she's
there.
not, okay, all right, no contact with the complainant remains. January 26th at 9 a.m. for the pretrial.
Thank you, Your Honor.
Thank
Thank
you.
you.
All right, see you later.
Thank you.
Bye-bye. How about Canton, Mr. Burt?
We do have Cannon, Your Honor.
All right. We're done in Westland.
Yeah, we got all of them except Huron.
All right. We'll go to Canton now.
Detective Evans.
Hello, Detective Evans. Magistrate Ramsey Heath, we're ready for your arraignment.
Okay, perfect. Thank you.
Thanks. Bye-bye.
Goodbye.
I'm bringing in Livonia too.
Were you gonna do the probable, did you want to do the arraignment right after the probable cause? Or if you were gonna do the probable cause for Cannon and Livonia, I'm not sure if Dearborn is there, then I can knock out the Huron interview while those are being performed, you know?
Why don't you go ahead and do that? We'll do that. We'll put you in with Huron for just a minute, okay?
Okay, thank you.
Okay, for Huron, please accept the invitation to the breakout room. Sending you to room 1.
Thank you, Your Honor.
Mm-hmm. All right, hello in Canton. One moment, please. Hello, is this Livonia? This is Magistrate Ramsey Heath. All right. Hi, I'm ready to do your probable cause hearing and then shortly thereafter the arraignment.
Okay.
Thank you. Bye-bye. All right, to Canton. Is that Detective Evans? You're going to be doing the probable cause testimony here?
Morning, Your Honor. Detective Evans is on his way. He should be here within a minute or two.
Okay, very good. Thank you.
Okay.
Morning, Your Honor.
Good morning. How are you today?
Good, how are you?
I'm good, thank you. All right. this is going to be People versus Thomas Joseph Brooks, correct?
Correct.
Okay, I've got one count of retail fraud in the first degree with a HAB 4 notice. Your name and badge number for the record, please.
Detective Mark Evans, Canton Township Police Department, badge number 5994.
Thank you. And are you going to be testifying from personal knowledge or an investigator's report?
Investigator's report drafted by me, Your Honor.
Thank you. Please raise your right hand. Swear or affirm that everything you're going to tell me is the truth.
I do.
Go ahead with your probable cause testimony, please.
On 1/14/2023, at approximately 19:47 hours, officers were dispatched to retail fraud in progress at Walmart located at 39500 Ford Road. Loss prevention advised a white male wearing a face mask and all black clothing was concealing approximately 30 packs of trading cards in a tote. Officer Kosk arrived and loss prevention advised the male was exiting the grocery side doors and bypassed all points of purchase without offering payment for the concealed merchandise. They attempted to stop the male and he fled on foot. Officer Kosk was pointing in the direction of a silver Ford Escape that was driving southbound through the parking lot. As the vehicle the suspect had gotten into, Officer Kosk caught up to the vehicle, which is bearing an Ohio license plate, Tom Lincoln Mary 7582, and initiated a traffic stop. The vehicle came to a stop and Officer Robinson boxed the vehicle in from the front. Officer Kosk ordered the driver out of the vehicle and it was a female, identified as Shauna Fulner. Officer Kosk observed a male in the right rear passenger seat wearing all black. Officer Kosk ordered the male out of the vehicle and took him into custody. He was identified as Thomas Brooks. Officers then spoke with LP Representative Jesse Yeager. Yeager reported that he was conducting video surveillance when he observed Brooks in the trading card section. He was seen selecting multiple packages of trading cards and placed them into a tote he had with him. Once he put the lid on the tote, he contacted Canton Police Department. Yeager observed Brooks bypassing all points of purchase without offering payment. He attempted to stop Mr. Brooks and Mr. Brooks abandoned the car and fled on foot. Total value of the items taken was $1,885.58. And Mr. Brooks also has 7 priors for retail fraud between second and first.
Okay, thank you. All right, I do find probable cause to support the charge of retail fraud in the first degree. We'll need to hold off just a moment for counsel to get back to do the actual arraignment. Stand by while we do probable cause hearing in Livonia, please. Okay, to Livonia. Are you Detective Kosk?
I am, Your Honor.
All right, good morning to you still. Go ahead and state your name and badge number for the record, please.
Yes, Cameron Koss, Koss 718.
Thank you. And are you going to be testifying from personal knowledge or an investigator's report in the case of People versus DeAndre Lewis Henderson?
From an investigator's report.
Thank you. Please raise your right hand, swear or affirm that everything you're going to tell me is true to the best of your information and belief.
Yes, it is.
All right, thank you. Go ahead with your testimony, please.
Yes.
I'm sorry, we've got, just for the record, we've got one count of assault with intent to do great bodily harm less than murder or by strangulation and one count of aggravated domestic violence, meaning a serious or aggravated injury resulted, and then one count of misdemeanor domestic violence. Now, sorry, go ahead.
Yes, on October 25th, 2022, the victim, Ms. Koopmans, reported to Livonia PD that in mid-December 2021, around 8:00 p.m., her and her husband, DeAndre Henderson, were arguing at Henderson's residence located in Livonia. Henderson was yelling and spitting at Ms. Koopmans and then proceeded to grab her by the hair and pull her backwards, which she said hyperextended her neck. Koopmans stated that some of her hair was pulled from her head. She attempted to retreat to the bathroom. However, Henderson followed her. Henderson followed her into the bathroom, attempted to kiss her. Koopmans stated she faked a panic attack so he would leave her alone. She stated that he then attempted to run out of the house, but was tackled by Henderson. They began to wrestle throughout the house. Back in the bedroom, Henderson used his body weight to smash Koopmans into a closet organizer pole about 10 times. She reported she was unable to walk and her foot went numb from this assault. Their arguing continued. Koopmans said she told Henderson she wanted to leave for the night, but he refused to give her her wallet, keys, or passport. At 10 p.m., Koopmans again asked for her property back, and they started arguing and yelling at each other again. Koopman stated that Henderson was on top of her and began to strangle her while holding her arms down with his knees. Koopman stated that eventually Henderson got off of her and stood at the end of the bed. Koopman stated her shirt was loose, and during the struggle, it revealed her breast. Henderson then grabbed Koopmans by her right breast and pulled her. This caused extreme pain. Eventually, Henderson left the house and left Koopman's property. She was able to retrieve her property and leave. She has not seen him since this assault. She said she waited to report this incident to Livonia PD because she feared retaliation.
All right, thank you. Looking at the investigator's report, it says she reported that there were several prior domestic violence incidents where she was assaulted, but she did not report them. Is that correct?
Yes.
All right. Does the defendant have any assaultive criminal history that you believe I need to know about in setting bond?
No.
Thank you. All right, thank you. I do find probable cause to support the charges here. I am signing this at this time. We're going to be just a moment while we wait for counsel. Oh, there he is. Okay. And we'll go ahead and do the arraignment. I'm going to start in Canton with the arraignment on Mr. Brooks, and then we will come right back to you, Livonia, to do the arraignment on Mr. Henderson. Okay.
Okay. Thank you, Your Honor.
All right. Thank you. All right. Thomas Brooks, please step forward. All right. Good morning.
Morning.
State your name for the record, please.
Thomas Joseph Brooks, 5968.
Thank you. All right, counsel, People versus Thomas Joseph Brooks.
Yes, Your Honor. Brandon Bird on behalf of Thomas Brooks. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I will hear your argument as to bond. I note it is non-assaultive, and I don't have anything assaultive in the criminal history that I can see, even though he is habitualized. I'm not seeing anything assaultive there. Go ahead.
Yes, Your Honor. Mr. Brooks, nothing assaultive. Age 54, Your Honor. As you stated, habitual force, but my client did indicate to us there's been nothing since that 2005 incident, Your Honor. He is on disability right now. It'll be difficult for him to afford a monetary bond. Actually, he can't afford any monetary bond. Any amount of bond would be like a remand to my client at this point, Your Honor. Respectfully, this is a non-assaultive allegation. We asked this court for a personal bond.
All right, thank you. I don't see any danger to the community here. I don't see any flight risk, quite frankly, given the prior record, the number of retail fraud convictions. He shows up for court. I don't know if the next judge is going to decide to lock you up to stop you from stealing, Mr. Brooks. But for me, I don't see a danger to the community, and I don't see a flight risk. So this is going to be a personal bond in the amount of $10,000.
Thank you, ma'am.
Okay, your next court date is going to be January 27th, January 27th for your probable cause conference. That's an in-person hearing at 9 a.m., January 27th. After that, your preliminary examination is set for February 3rd at 9 a.m. for the prelim. Okay, you are not to go back to that Walmart store. No contact with Walmart on Ford Road. Don't go there.
Promise.
Thank you.
All right, thank you.
Okay. All right, Canton, thanks. See you later.
Thank you, Your Honor. What's it? Can you use the phone? Yeah.
Okay, to Livonia, going to the arraignment portion on People versus DeAndre Lewis Henderson. Counsel.
Yes, Your Honor. Brandon Bird on behalf of DeAndre Henderson. My client waives his right to the formal reading, was advised his constitutional rights, so stand mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
As to bond, Your Honor, 34-year-old lifelong resident of Michigan, Your Honor. My client lives alone, indicates to us that the complaining witness is his wife, but they never lived together, Your Honor. and he doesn't contact the complaining witness. The complaining witness actually texts him every day, but he tries to maintain no contact with the complaining witness in this matter, Your Honor. He didn't know about this warrant. This warrant was signed a year later, actually. It indicates that the incident date was around December 1st, 21 to December 12th, 21, and it wasn't signed until December 1st, 2022, Your Honor, which always sparked some curiosity within me, but notwithstanding, he indicates to us out of 34 years of life, he has no prior criminal history, not on probation and parole, no pending cases, Your Honor. At 34 years old, he built a truck. He built a trucking company, and I understand the serious nature of these allegations. When my client went about 33 years of his life with no prior criminal history. The reason he's here today is because he was stopped on a traffic stop on his route while he was working, and there has been no incident since then. As stated earlier, my client does maintain his innocence and looks forward to his day in court in this matter. And respectfully, Your Honor, we ask this court for a personal bond.
All right, thank you. To the officer, when are you showing, this must be the case maybe that was mentioned to me yesterday where there was some thinking that a warrant or complaint had been previously signed. That's not it? That's a different one? Okay, all right. So I'm hearing that so she came in October of 2022 to report this incident that purportedly happened in December of 2021. Is that correct?
Yes, that's correct, Your Honor.
Okay, thank you.
Or that's correct as far as the date. She didn't actually come in person. She resides in Canada, I believe. So she called and reported this over the phone.
She called and reported it. Okay, thank you. All right. It is a very curious case. I mean, that there's a long time of waiting. What's described as a pretty significant assault, but I have nothing about any kind of medical treatment being sought or received by the complainant. Noting that the parties part of the report says that the complainant has said she consistently reaches out to him because she wants a divorce and he will not file unless she meets up with him, which she refuses to do. So there's some backstory going on there as well. Your attorney probably told you not to talk until he tells you to. There's a reason. That was inuring to your benefit. Okay, so it don't interrupt me and tell me something's not true. When I'm saying she said she consistently reaches out to you. So there are some curiosities here. Tell me, Mr. Bird, about this, the trucking company, the work, I'm trying to figure out what to do here.
I didn't go into depth about the trucking company, Your Honor, but he does own it. He did tell me that he owns a trucking company, Your Honor. He has people working for him right now, but what he explained to me that he really needs to get back to that. The people that's working and maintaining his business right now isn't responsible enough to keep his business going, and him being in jail could potentially destroy what he built.
She's in Canada. Does your client have a passport?
I'm not sure, Your Honor. I
didn't
report.
To a passport, please.
Excuse me, Mr. Henderson. This is your attorney speaking. Yes. Can you hear me? Do you have a passport?
No.
You have an enhanced driver's license that allows you to travel to Canada? Do you have anything that allows you to travel to Canada without a passport? You want to ask him that, Mr. Bird, please? I don't want him going there.
Sorry. Do you have anything enhanced driver's license, where you can go to Canada?
I do.
All right. Right, I'm gonna set your bond at a personal bond because of what I said. There's been a long time since this is alleged to have happened, over a year. There's been no physical interaction between the parties, in-person interaction since, even according to the complainant. No reaching out to her by the defendant, even according to the complainant. She's reaching out to him. And I don't have anything, given the age of what's described, and it's described in enough detail that concerns me that it did really happen, but I don't have any kind of medical treatment or anything from what is described as a fairly significant assault. So I'm going to give you a personal bond, but I do not want you leaving. I do not want you going to Canada. So part of what makes me comfortable is that she's in a completely different country at this point. She's in Canada. That's where she resides. You are not to go there. All right. Is that clear?
Yes, ma'am. Yes.
Okay. You don't have to pay to get out of jail today, but if you violate that provision of my bond or any other provision of my bond, you'll find yourself sitting back in there without the ability to get out unless you happen to have $200,000 in cash on hand. Do you understand that?
Yes. I have no intention.
There is to be no contact with the complainant. All right. No verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be a violation of the condition of the bond. I understand divorce proceedings may be coming. The next judge can evaluate that and determine how you guys need to communicate to get that done. All right, next court date, January 26th for the probable cause conference at 9 a.m. and February 2nd at 9 a.m. for the preliminary examination. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. All right, I've got a file for Dearborn now. We'll go there unless are we going to have more for Dearborn?
No.
That's it? Okay.
So far, if nobody else is, no, see that, then they can't send that.
Okay, thank you. All right, before I go to Dearborn, I'm going to do a couple of probable cause hearings here for Detroit real quick, Mr. Bird, just so they can get those processing for DDC, and then we'll go over to and start in Dearborn. And
sounds good, Your Honor. Thank
you. Thanks. Huron's still in the breakout room, I guess. Let me close that room so they can get out. Okay, to Huron, you're going into the waiting room for a moment. We'll get started in just a moment.
Detective Randolph.
Hello, Detective Randolph. Magistrate Ramsey Heath calling you on People versus Shantez Robinson. Hold on one second. What is happening here? All right. I sent me the CCH. Thank you. All right. People versus Shantez Robinson. Are you going to testify from personal knowledge or investigator's report?
Yes, this is my investigation report, ma'am.
All right, thank you. Please raise your right hand. Go ahead and state your name and badge number for the record.
Detective Tamara Randolph, badge D577.
Thank you. And raise your right hand. Swear affirm that everything you're going to tell me is the truth.
Yes.
Thank you. I've got 1 count of domestic violence and 1 count of malicious destruction of personal property, 200 or more, but less than 1,000. Go ahead with your testimony, please.
Okay, this matter is regarding Shantez Kishi Robinson and Natisha Harris. They are married. This incident took place on January 14, 2023 at the location of 3509 Bedford Street at 8:30 a.m. On the above date and time, South 54 was dispatched to the above location for domestic violence. When officers arrived, they spoke to the complainant who was waiting on the front porch. She stated that during an argument, the defendant punched her 1 time on the left side of her face. The defendant stated she then called her mother, and the defendant snatched the phone and threw it in the kitchen. Then picked it up and threw it down the basement stairs, shot her in the front and back of the phone. While officers was interviewing the defendant exited the house, speak to officers, at which time he was arrested. Officers observed small scratches on the defendant's face. Officers asked the complainant how the defendant was scratched, and she stated that he tried to stomp her and she defended herself. Medicine was refused by both parties. The defendant was conveyed to CDC for processing and housing. The value of the complainant's iPhone 13 is $950. That concludes my testimony.
Thank you. I do find probable cause to support the charges. I'm signing this now and sending it on for processing. Thank you.
Thank you, ma'am.
All right.
Bye-bye.
Quickly, there's that one, Madam Clerk for City. There's another out county file that I'm done with there. Get this one done quickly.
Detroit Police Homicide Section, Detective Dawson, may I help you?
Hello, Detective Dawson, Magistrate Ramsey Heath calling you now, and Bradley Thurman. This is his second case for the day. Go ahead and state your name and badge number for the record, please.
My name is Detective Darrell Dawson, badge number D2639.
Thank you. And are you going to testify from personal knowledge or investigator's report?
Investigator's report.
Okay, thank you. Please raise your right hand, swear affirm the contents of that report are true to the best of your information and belief.
Yes, I do.
All right, thank you. Go ahead with your testimony, please. I've got one count of murder in the first degree, one count of felony murder, one count of armed robbery, one count of felony firearm. Okay, 1, 2, 3, 3 counts of felony firearm going along with those preceding offenses. Go ahead with your testimony. You can go ahead.
I'm sorry. Good morning. This is Detective Dawson. Like I say, I was assigned this case. And like I say, this is my first case. So I did type the investigator's report.
Okay, well, you're already sworn to the truthfulness. Yes. So you can read from the investigator's report if you want, but you have to give me some testimony to meet the elements of all of the offenses. It may be given the number of charges, that might be the way to go.
Okay, I'll read from it then, because this is my first time doing this.
All right.
Let me see here. Okay, on December 29th, 2022, Darrell Dawson, badge number D2639, and police officer Brandon Jordan, badge number 2501 of the Detroit Police Department Homicide Section, made beverage one liquor located at 19322 Grand River and reviewed surveillance video of the shooting carjacking. On December 28th, 2022, at approximately 10:58 p.m., victim arrived at the location in a gray 2018 Dodge Journey 4-door with a Michigan license plate of David Union Nora 1663. At 10:38:02 p.m., a black older model 2010 to 2015 GMC Terrain 4-door vehicle is seen in the alley westbound behind 19322 Grand River. At 10:38:20 p.m., the Terrain then proceeds northbound on West Outer Drive and eastbound on Lincolnshire Street. The Terrain stops on Lincolnshire Street east of 4585 West Outer Drive and lets Defendant 1 out. Defendant 1, wearing all black clothing, is seen walking southbound on West Outer Drive. Defendant 1 walks eastbound through the alley behind 19322 Grand River. The victim exits the location walking to her vehicle, at which time the suspect walks up to the victim and shoots her one time in the chest. Victim falls to the ground and the suspect goes through her pockets, taking items including her car keys. Defendant one leaves the location in the victim's vehicle northbound on West Outer Drive and makes a right-hand turn onto eastbound Gainsborough. On December 29th, 2022, an armed robbery occurred at the Family Dollar located at 401 East 7 Mile Road in the city of Detroit. Defendant one is captured on video wearing the same clothing that he had on the day before when he shot and killed the victim at Beverage One Liquor at 19322 Grand River. Defendant one enters the Family Dollar armed with a black and silver semi-automatic handgun in his hand. As defendant one is leaving the location, he fired one shot in the air before leaving the location. The victim's gray 2018 Dodge Journey was recovered from the parking lot of the Family Dollar on the day of the armed robbery. The video was recovered from a Adamo group at 320 East 7 Mile Road across the street from the Family Dollar that shows defendant one arrived at the location in the victim's gray 2018 Dodge Journey. On January 11th, 2023, Detective Darrell Dawson, badge number D2639, OIC, officer in charge, reviewed camera footage from 19322 Grand River on December 28th, 2022. On December 2022 at approximately 10:36, 16 p.m., a black 2010 GMC Terrain four-door with a large bin in the right front passenger side is observed pulling into the parking lot of 19120 Grand River. On December 28, 2022, at 10:34 p.m., defendant one is seen walking westbound on Grand River in front of the Little Caesars Pizza located at 19116 Grand River. Defendant one gets into the right front passenger side of the black GMC Terrain that was stopped in the parking lot of 19122 Grand River. The vehicle continues westbound through the alley behind the Beverage One Liquor located at 19322 Grand River moments before the shooting. On January the 12th, 2023, Sergeant Michael Dowdy and Detective John L. White, after reviewing the footage from Grand River Workplace located at 19120 Grand River, and advised crime analyst Nadia Dixon to check the flock imaging system for a black GMC Terrain four-door with a Michigan license plate of David Lincoln Victor 052. Sergeant Dowdy ran the license plate through the Law Enforcement Information Network lead. The vehicle was registered to an Antonio Marcus Davis, black male, 11-13-70 of 19743 Stout, Detroit, Michigan, 48219 as defendant two. Sergeant Dowdy checked clear to find a phone number for defendant two. There were two phone numbers registered to defendant two, 248-893-9875 and 586-229-4392. The cell phone carrier for both phone numbers is T-Mobile. Sergeant Lance Sullivan of the Detroit Police Violent Crimes Task Force Unit completed a geofence search warrant for the shooting carjacking at Beverage One Liquor, 19322 Grand River, and the armed robbery at the Family Dollar located at 401 East 7 Mile Road. The return geofence search warrant revealed two phone numbers, 248-893-9875, 586-229-4392, that were at both locations during the time of both incidents. Defendant two, current cell phone activity providing information of active calls that show defendant two contacting Ms. Jayla Shai's telephone number on January 12, 2023, who was with defendant one doing a traffic stop on January 6, 2023. See Superior on report number 2301060275. On January 13, 2023, defendant one and defendant 2 were taken into custody and transported to the Detroit Detention Center. On January 13th, 2023, Jayla Shy, black female, 62398, a passenger in defendant 1's vehicle, was conveyed to the homicide section location at 1301 3rd Street. Ms. Shy spoke with Detective John L. White and Detective Gallimia. Ms. Shy stated she was with Davion on January 12th, 2023, and stated they spent the night at 15090 Wickham Street. Ms. Shy stated on January 13th, 2023, that she took Davion over to his uncle's house on Abington Street when they were stopped by the police. Ms. Shy was shown video footage from 19120 Grand River Workplace when the black GMC Terrain pulled into the parking lot of the location. Ms. Shy identified the victim as defendant 2's victim. Ms. Shy also identified the male who got into the right front passenger seat of the vehicle as defendant 1. Ms. Shy was shown a video of a male armed with a gun in the parking lot of 19322 Grand River on December 28, 2022. Ms. Shy identified the male in the video as defendant 1. Evidence recovered. On January 13, 2023, the Detroit Police Homicide Section, Northwest Squad, and other members of the Detroit Police Department executed a search warrant at 18803 Orleans Street in the city of Detroit. Sergeant Dowdy and Detective Andrew Arnston of the Homicide Section recovered a key ring with a black Dodge key fob on it, along with a Kroger's Plus card, a SEIU key ring, 1 gold house key, 1 silver house key, and a dark metal tag on it under a mattress in the bedroom belonging to defendant 1. The key recovered was confirmed to be the victim's key fob to her gray 2018 Dodge Journey that was taken during the shooting carjacking at 19322 Grand River Beverage 1 Liquor. Interrogation. On January 14, 2023, Detective John L. White and Detective Gulamia of the Homicide Section made the Detroit Detention Center to interrogate Defendant 1 and Defendant 2. Defendant 1 gave a full confession regarding this case regarding shooting and carjacking the victim and taking items from the victim. Defendant 2 invoked his right to an attorney and refused to give a statement.
All right, I do find probable cause to support the charges. I am signing this and sending it for processing.
Thank you. Thank you so much, Your Honor.
Thank you. All right, bye-bye.
You have a good day. Bye.
I do the same. Bye-bye. This one.
Narcotics Prisoner Processing Unit, Officer Mitchell, Corporal Mitchell, so you have an out.
Okay, Corporal Mitchell, I'm calling you on People versus Jacob Duran, but I'm giving you a call right now to tell you we have the same problem as I think yesterday, where we've got count 1 listing charging defendant as being in possession of a mixture containing cocaine, but according to your investigator's report, there's no cocaine identified. There is fentanyl.
Ma'am, let me see. Is this for Jacob Duran?
It is. Count 1, it says he's in possession of a mixture containing the substance cocaine. Your investigator's report in the last paragraph talks about the testing of the drugs. There's no cocaine. There's fentanyl. So I just wanted to let you know so you could work on getting it
Okay.
corrected, because I gotta move on to some other things, okay?
All right.
Thanks, bye. So Madam Clerk, for city, this one's gonna come back for correction.
Okay.
That one that I just gave you on Walker, what's the officer's name and number there?
It is Zeno,
Okay,
5965261.
thank you. All right, let me get Huron done. They've been waiting forever. Okay, sorry, let's get Huron done. Christopher, they've been. Sorry, we had a homicide case that had to get done. All right, Officer, are you Officer Rickelman?
Officer, excuse me, Officer Castelli.
Castelli, and you'll be testifying. Thank you. You signed the complaint, so you'll be testifying as to probable cause, correct?
Correct.
Okay, thank you. Please state your name and badge number for the record.
Officer Castelli with the Huron Township Police Department, badge number 27.
Thank you. And are you going to testify from personal knowledge or an investigator's report?
From an investigator's report.
Thank you. Please raise your right hand, swear from the contents of that report are true to the best of your information and belief.
I do.
Thank you. Please go ahead with your testimony.
On January 17th of 2022, at approximately 7:31 p.m., Officer Stewart and Sergeant Henley of the Huron Township Police Department were dispatched to 23645 Deerfield, which is in Huron Township, County of Wayne. Officers conducted an investigation and reported that defendant Delaney Landon admitted to assaulting victim Mackenzie Droyer. The victim advised that the defendant struck her in the face with a bottle of liquor. The victim obtained a facial laceration and was transported to Trent Beaumont Hospital for treatment. The victim wishes to prosecute.
Thank you. I do find probable cause to support the charge of felonious assault. Signing now. Let's move on to the arraignment portion of the proceeding. People versus Delana May Landon. Is that you?
Yes.
All right. Thank you. Counsel.
Yes, Your Honor. Brandon Bird on behalf of Delana Landon. My client waives her right to the formal reading, was advised her constitutional rights, and will stand mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. In terms of bond, I'll hear your argument.
Your Honor, 23-year-old lifelong resident of Michigan, Your Honor, has a 5-year-old child who she's the sole support of. Her mother's disabled. She's her mother's caregiver on a walker in a wheelchair at this moment, Your Honor. She indicated to me that she has a retail fraud from about 5 years ago, Your Honor, but that's her only conviction. She's not on probation or parole, no pending cases. She does do delivery, work for a delivery system, but she makes well below the 200% poverty guidelines, especially trying to take care of her mother and her daughter, Your Honor. I understand this is an assaultive allegation, but the incident date stems back roughly a year ago, almost exactly a year ago now, Your Honor. My client hasn't seen the complaining witness since, doesn't want any contact with the complaining witness, doesn't have any reason to contact with the complaining witness, Your Honor. And respectfully, we ask this court for a personal bond.
All right, thank you. You know, one of the curious things about this investigator's report is that the complainant said she thinks it was this defendant that hit her. I was then looking more into the investigator's report because there was another person who also said he was hit or in at least witnessed things. And then he said he thinks it was her, but he couldn't tell who was hitting who. You know, so sounds like a bunch of people were in a house, started drinking, and chaos broke out at some point. Another witness said she didn't see anybody get hit with a bottle. So given the age of the case, of the allegations, and given some of those other statements in here, that, certainly defendant is not presumed guilty at this time. And there are some factors in that investigator's report that I think are questionable in terms of what happened. So I'm not going to presume her guilt of this at this time and judge her to be any danger to the community on the basis of the charge in front of me or anything in her past that I've heard of. In terms of flight risk, I don't see any reason to be concerned about flight. We've got a local address. So I am going to set a personal bond here. I'm going to set a personal bond in the amount of $100,000. Ma'am, that means you don't have to pay to get out of jail today. All right. But it does mean that if you violate the conditions of my bond, you can find yourself sitting back in there without the ability to get out in case you have access, unless you have access to that kind of money. All right.
Yes.
So no contact with the complainant, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact with her would be considered a violation of the conditions of my bond. Your next court date is going to be January 25th for probable cause conference. And after that, preliminary examination is set for February 1st at 9 a.m. Okay, thank you.
Thank you.
All right, thanks again. So sorry for the wait for you this morning.
No problem.
Thanks.
Thank you, Your Honor.
Thank you. Let's take care of that one real quick. There. I signed that, right?
Are we gonna do Dearborn, Your Honor?
Yep, I'm gonna go Dearborn right now.
Sounds good.
So that Duran, they came through. The judge needs some information, so we're waiting.
Hello, Dearborn. Hey, call.
Dearborn Police, Detective Bilski.
Hi, Detective Bilski. We're ready for you on arraignment.
Okay.
Okay.
On my way down.
Thanks. Bye.
Detroit Police, Corporal Zeno speaking.
Hey, Zeno, Ramsey Heath, name and badge number for the record, please.
Corporal Zeno badge 210 with the Detroit Police Department Investigation Operations Unit Court Officer.
Thank you. People versus Kareem Walker from personal knowledge or investigator's report.
An investigative report.
Thank you. I've got one count of home invasion in the first degree, one count of resisting and obstructing, and one count of domestic violence. Please raise your right hand, swear or affirm everything you're going to tell me is true to the best of your information and belief.
I do.
Go ahead with your testimony, please.
Okay. Victim 1, Miss China Hunter, has been dating the defendant, Mr. Kareem Walker, for approximately 1 year. Victim 2, Miss Gwendolyn Taylor, is Miss Hunter's mother. The injury to Miss Hunter's eye can be seen on body-worn camera. Heather Fitzpatrick at 2:05. On January 15, 2023, Scout 1133, manned by P.O. Gyers and Greer, responded to a domestic violence assault battery at 19131 St. Auburn Street in the city of Detroit. Scout 1151, manned by P.O. Jitter and Darling, and Scout 111, manned by Hoy and Jones, assisted the primary unit. Upon arrival, victim 2, Gwendolyn Taylor, informed the scouts that the defendant, Kareem Walker, had just walked next door to the gas station. Ms. Taylor describes the tan hoodie with a front graphic Mr. Walker was wearing to the scouts. Scout 1133 walked to the gas station. observed Mr. Walker. The scout observed multiple scratches on Mr. Walker's face. Mr. Walker told the scouts he had an altercation with his girlfriend, the victim, China Hunter. He stated the daughter, referring to victim one, is a little fucked up in the face. Mr. Walker told the officers Ms. Hunter had been pushing him and smacking him in the face, so he had pushed her off. He stated he pushed her, and because she light-skinned it, she bruised up and got a mark, nothing major. The officers walked with Mr. Walker back to the home so they could speak to Ms. Hunter. During this conversation, Mr. Walker refused to speak to P.O. Geyer, stating he could not understand due to the color of his skin, referring to P.O. Geyer being a dark-skinned black man, and would only speak with P.O. Greer, a Caucasian male. Officer Geyer went into the home and spoke with both Ms. Hunter and Ms. Taylor. P.O. Geyer observed Ms. Hunter had a swollen welt that was turning black and blue on the right side of her face. He offered her medical attention, but she declined. Ms. Hunter confirmed there had been a physical altercation and Mr. Walker had struck her multiple times, hitting her in the head with a closed fist. She stated she ran inside the home. Mr. Taylor stated she closed behind Ms. Hunter, but Mr. Walker forcefully pushed through the door. Okay. P.O. Jeter could smell intoxicants coming from Mr. Walker. P.O. Jeter told the assisting officers to cuff Mr. Walker. The officers gave commands for Mr. Walker to put his hands behind his back as they began to reach for him. Mr. Walker began to pull away, making his arms rigid, and was actively trying to pull away. P.O. Darling.
Okay, you can stop. We have probable cause as to all counts. Signing, sitting on for processing. Thank you.
You're welcome.
Okay. Okay, Dearborn, officer, is it Bilski? Who do I have doing probable cause?
Yes, Your Honor, Detective Mark Bilski.
All right, good morning to you. Hold on one second.
Good morning.
Yes, okay, thank you. Thank you for that catch. All right, I've got People versus Marie Ostrander. I've got one count of operating while intoxicated with a third offense notice. I've got one count of operating while intoxicated with an occupant less than 16 years old. I have one count of child abuse in the 4th degree based upon driving a vehicle with a child in it while intoxicated, and one count of operating while license suspended, revoked, or denied. Officer, are you going to testify from personal knowledge or an investigator's report?
Investigator's report.
Thank you. Please raise your right hand. Swear or affirm that everything you're going to tell me is true to the best of your information and belief.
Yes, I do.
Thank you. Go ahead, please.
Yes, Your Honor. On Friday, January 14th, 2023, Dearborn police officers were dispatched to the intersection of McKinley and Carlisle, which is located city of Dearborn, County of Wayne, state of Michigan, on a report of a traffic accident. On arrival, Officer Lucido observed 2 damaged vehicles and made contact with the victim vehicle driver, who advised that she was not injured and declined rescue. Officer Lucido then made contact with the driver of the second vehicle, a blue Ford Escape, bearing Michigan license plate Edward Lincoln William 8819. Alexis Ostrander was still seated in the driver's seat of the Escape. Officer Lucido also observed Ostrander to have a cut to her lip, which was slightly bleeding, and observed 3 small children in the vehicle. Those children were later identified as Malik Bagaman, who was 6 years old. He was seated in the front seat and seat belted at the time of the crash. Mason Bagaman, 5 years old, and Violet Stevens, who was Alexis's daughter, Miss Ostrander's daughter. They were seated in the rear seat and were not seat belted, and none of the 3 children were in car seats. Officer Lucido, on making contact with Ostrander, asked her for a driver's license, to which she declined several times. Also, on speaking with Ostrander, she attempted to close the vehicle's door several times, and Officer Lucido was required to hold the door open. He then asked Ostrander when the last time she drank alcohol, to which she initially replied a year and a half ago. Officer Lucido asked Ostrander to exit the vehicle several times, and she eventually complied and agreed to perform field sobriety test. As on exiting the vehicle, Ms. Ostrander was very unsteady on her feet, and Officer Lucido again asked when the last time she had alcohol, and she responded yesterday, and that she consumed vodka. Officer Lucido performed the horizontal gaze nystagmus test on Miss Ostrander, to which he observed a lack of smooth pursuit in both eyes and nystagmus at maximum deviation, which is a fail. He then attempted to have Ostrander perform the one-leg stand test. While explaining the test to Ostrander, she was unsteady on her feet and attempted to start the test prior to being told to do so. Further attempts were made, but she continued to be unsteady. To prevent her from falling and injuring herself, he stopped the test and placed her into custody. Ostrander read her preliminary breath test rights, and she agreed to take the test, which revealed her blood alcohol content to be 0.264, and that was at 2:52 p.m. Children's parents responded and took custody of same. All of them declined rescue. She was taken, search warrant was authored and signed by Judge Summers, 19th District Court. She was taken to Corwell Health, where a blood draw was executed. Those results are pending. We were able to review CCTV footage of the accident. The accident shows the victim vehicle stopping at the stop sign at McKinley and Carlisle before proceeding through. And then it shows Ostrander's vehicle completely disregard the stop sign at a high rate of speed, approximately 35-40 miles an hour, and rear-ending the victim vehicle.
Thank you. And we have a PBT at 2.264, is that correct?
Gonna verify, I know it's 0.26, just want to verify. Yes, 0.264.
All right, thank you. I do find probable cause to support all charges. Now signing this, noting for the record that the complaint does contain the two previous, because it is relevant to the charge, it does contain the two previous convictions of same operating while intoxicated or impaired. One in December of 2018 out of 17th District Court. Sorry, I think there's a 2017 as well. Give me 1 minute, just looking through this complaint. December 19th, 2018. Officer, can you direct me to this is listed as a third, it's got a third offense notice, making it a felony. I'm looking for priors. I'm seeing December 19th, 2018 out. Oh, I'm sorry, March 8th, 2017 Correct. Out of 17th District Court, and then December 19th, 2018 out of 19th District Court. Okay, so I do
That's
find
correct, Your
probable
Honor.
cause for the charges. Thank you. We'll move on to the arraignment portion. People versus Alexis Ostrander. Ma'am, is that you?
Yes.
Okay, thank you. Counsel.
Yes, Your Honor. Brandon Bird on behalf of Alexis Ostrander. My client waives her right to the formal reading, was advised her constitutional rights, and will stand mute.
Great, thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
Your Honor, 28-year-old lifelong resident of Michigan, Your Honor. She has one 4-year-old who she's the main supporter of. One 4-year-old daughter who she's the main supporter of. She lives with her daughter, Your Honor. Does everything for her. Actually, her daughter has to be in school tomorrow, and my client needs to be at work, Your Honor. She does have criminal convictions, but they are for the operating while intoxicated. And she doesn't have any other criminal convictions besides those operating while intoxicated, Your Honor. State since her last operating while intoxicated, she hasn't received a ticket. Actually, that's because most of the time she hasn't been driving. My client is a waitress, makes well below the 200% poverty guideline, and it'd be difficult for her to pay a monetary bond. It'd be very difficult to pay a monetary bond, especially with the responsibility of the 4-year-old daughter that she has. She has made some steps to try and improve her life, try and better her life. She graduated a couple months ago to be an esthetician from a trade school, Your Honor. And like I said, she hasn't received any tickets since then. She hasn't been driving while license suspended. She wants this court to know that this isn't a reoccurrence of her driving. She just recently got a car. She paid somebody to go to the Secretary of State. That's still not an excuse to be driving without a license suspended, and it's not an excuse to be driving while intoxicated. But she has been trying to get her life together, Your Honor. My client, one thing that stood out to me, she recognizes she needs help. She recognizes she needs help, Your Honor. But respectfully, I understand this is the third offense. This the longest she's been away from her daughter since she had her daughter. I understand there's a child abuse charge in there because of the driving while intoxicated. But I guarantee you my client won't make that mistake again, Your Honor. We're asking this court for a personal bond. If the court's just not inclined to a personal bond, then a personal bond with an alcohol tether. I don't see her as a flight risk, Your Honor, but I can understand this court's worried that my client may get behind the wheel again. And we're asking that she please be able to maintain contact with her daughter. She's all her daughter has, Your Honor. And respectfully, we ask this court for a personal bond, as stated earlier. If this court's not inclined to just a personal bond, then a personal bond with an alcohol tether.
Here's the problem with an alcohol tether. She gets very intoxicated and then does things that she knows she's not supposed to do. Because I believe she loves her daughter. But she endangered her daughter's life. She endangered the lives of, looks like someone else's 2 children. 0.08 is the level of intoxication, and I'm hearing she's at 0.26. Highly intoxicated. Blowing through a stop sign could have killed someone, did in fact cause an accident. And so we talk about operating while intoxicated as if it's not an assaultive offense. But a whole lot of people were put in danger of being killed, quite frankly, here. It's the 3rd OWI in a very short period of time. There's nothing that makes me believe that if I put an alcohol tether on her, she's still not going to drive. It'll go off. It'll tell us that she's intoxicated. But I think that if she had the ability to make good decisions when she's intoxicated, and I believe she's got a problem with alcohol, that she wouldn't be in this position, period. Okay. If I had a treatment center that I could order her into, counsel, as a straight inpatient as a condition of bond, I would do that at this time. But I don't have any at my disposal. And my job is to protect the community and protect her children who don't have any choice about whether mom gets intoxicated and sticks them in a car and starts driving with them. And so I'm going to keep her in custody. As I said, I do not believe that the jail is the best place, the right place for her. I think she probably needs treatment immediately and ongoing. And I hope that she will get it so that the community doesn't continue to be placed in danger, because even as a 3rd offense, they're not going to keep her in jail or prison forever. And so it needs to be treated. But at this time, I'm going to set a high cash bond because I think it's the only way to protect the community and her kids. And doesn't bring me any joy to do so.
Permission to speak, Your Honor.
Go ahead, counsel.
Your Honor, respectfully, I understand that it's been a short amount of time. But my client has made steps to come a long way. I understand that's why I didn't present it as a non-assaultive matter. And I didn't state it because I understand how you feel about it. I understand how the community feels about it. And I understand how I feel about it. Being intoxicated can ruin lives. And luckily, nobody was injured in this matter at this time. But even if we could get her, even if she does AA, if she goes to AA, meetings to be able to get out. Has an alcohol tether, AA. I'm pretty sure my client will abide by any condition this court's give her.
She's not though, counsel, because she doesn't even have a driver's license. Court's already told her not to drive. She doesn't abide by the conditions the court sets. She's not able to for some reason. If I thought she'd abide by a home confinement tether, I would do that. But I have zero confidence of adherence to that. And I believe people are in danger without it. Okay. So, and I appreciate that you said, no, you did not say it's a non-assaultive offense. I just said that's generally how we think of operating while intoxicated. But it presents great risk, especially in a case like this. I've got a conviction from 2017, a conviction from 2018. You know, we've got a few years in between, but the level of intoxication here too is just alarming. It's quite frankly surprising she was even still functional. So I'm setting bond in the amount of $750,000 cash. I intend for it to keep her in. If she's able to make that bond, she'll be subjected to a GPS tether with full home confinement. Probable cause conference, January 27th, 9 a.m. That's an in-person conference. After that, preliminary examination is scheduled for February 3rd at 9 a.m.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Thank you.
And thank you for hearing me out, Your Honor.
Thank you, counsel. Only work with what you got. That's it for Dearborn?
I believe that's all the out counties.
Okay, all right, we'll be ready for DDC in just a moment then. How we doing on interviews for DDC, do you know?
We're doing great. My law partners, Ms. Stevenson and Attorney Stevenson and Attorney Roberts are working diligently. I know we're done with the first page, and I'm pretty sure they have some more done by then. So.
Okay, great. Well, then as soon as I've got some files, we'll go ahead and get started. Thank you.
Sounds good, Your Honor. Thank you.
Okay, guys, I'm bringing in DDC. Thank you. Hey, DDC.
Morning, Your Honor. How are you?
I'm great, thanks. How are you today?
I'm doing well.
Good. I think they said they're ready to just go straight down the list.
Copy that. We can get started. Appreciate it.
Thanks. All right, Mr. Burns, Ms. Stevenson, who's coming in with me?
To the first one down. Bob.
Yeah, it's fine.
This is in my folders. Hold on, brother. Here's up here in the bullpen, man. Here you go. This motherfucker. Mark. Mark. I just told him. Robert. Willis, you got it, man. Total like it.
Hey, hey, couple of those. Korean Walker. Walk. W-A-L-K.
Shantez Robinson.
All right, stand by, Mr. Robinson, one moment. Oh, there we go. Okay.
Man, yeah. Boy.
Where'd that go, Mr. Robinson? Why are we on Robinson? Hold on one second.
It's in there. It's in the second page.
Has Robinson been interviewed?
Yes, Your Honor.
Okay. You're out of order. Okay. One second. Find it. I don't know. Sometimes they'll have somebody that just need to take out of order. Yes, they're sick or something. Okay. All right. People versus Shantez Robinson. Counsel.
Yes, Your Honor. Brandon Bird on behalf of Shantez Robinson. My client waives his right to the formal reading, was advised his constitutional rights, will stay in mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I've got one count of domestic violence, one malicious destruction, personal property. Go ahead with your bond argument, please.
One moment, Your Honor. Yes, Your Honor. My client indicates to us that he's a 45-year-old lifelong resident of Michigan, Your Honor. Indicates to us that he'd be living with his sister in a whole nother city, Your Honor. He does have a job who makes below the 200% poverty guideline and just started a month ago, Your Honor. And any amount of bond would be like a remand to my client at this point. He has 5 children. I understand this is assault of allegation, but my client looks forward to his day in court, and we respectfully ask this court for a personal bond.
Okay, thank you. Mr. Robinson has no prior assaultive history that I've been made aware of. I did take a look. So I don't have an ongoing concern about danger to members of the community in general. In terms of flight risk, sounds like there's enough ties here that I'm not going to worry about that. The only thing I wanted here to, for the most part, is no contact with the complainant and no contact with the address where this is alleged to have happened, all right? In furtherance of that, bond is set in the amount of $150,000 personal. That means you don't have to pay that to get out of jail today. But if you violate the conditions of my bond, you'll find yourself sitting back in there with this number attached to you in a different way. Do you understand?
Yes, ma'am.
No contact means no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact would be considered a violation of the conditions of the bond. The next court date here is going to be a pretrial on January 24th at 8:30 a.m. in front of Judge Garrett. Thank you.
Thank you.
Thank you, Yana.
You can start. First name Bradley, last name Thurman.
All right, we're out of order. Is there a reason we're not going just down the list? Because I don't want to get ahead of counsel in their interviews.
No, ma'am. Please, can you put it down? We got Valentine.
Has Thurman, 150 personal, has Thurman been interviewed, counsel?
Yes, Yana.
With respect to both cases?
Yes, Yana.
All right. Do I have that file yet?
Thurman?
Yeah.
Yeah, there's two together. One
Okay.
homicide and one robbery.
I got Dan Love. Sorry, I need a minute because I can't find files. There we go. Okay. All right, we've got two files on Mr. Thurman, counsel. I've got one file with, so People versus Bradley Thurman. This is 1, 2, 3, 4 counts of armed robbery, all involving different complainants. 1 count of discharge of a firearm in or out of building, and then 1, 2, 3, 4, 5 counts of felony firearm. In the other case, I have a murder in the first degree, felony murder, armed robbery, felony firearm times 1, 2, 3, 3 counts of felony firearm. Go ahead, counsel.
Yes, Your Honor. Brady Bird on behalf of Bradley Thurman. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
As to bond, Your Honor, 19 years old, rehabs houses, lives with his mother, has been a lifetime resident here. I did get a chance to listen to the probable cause conference, Your Honor, and I understand most likely this will be a remand, and to protect my client's rights and not to put too many facts on the record. I just respectfully ask for the court's decision in that matter. In that matter of the armed robbery, we're just asking for some sort of bond, Your Honor.
All right, thank you. In the matter involving the armed robbery, I mean, he's basically alleged to have kind of terrorized, it looks like 4 or 5 different defendants during an armed robbery with threats to kill. That bond in that case is going to be set at $4 million cash. If he's able to make that bond, he'd be subject to a GPS tether with full home confinement, cannot purchase or possess any firearms or other dangerous weapons during, the course of this bond, and no contact with any of the complainants in the case, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact would be considered a violation of the conditions of the bond. again at $4 million cash. This case set in front of Judge Jones. Bond review hearing, January 18th, 9:30 a.m. Probable cause conference, January 23rd, 8:30 a.m. Preliminary examination, preliminary examination, January 30th at 8:45 a.m. Second case, as you stated, counsel, is primary charge murder in the first degree, a pretty, very egregious act described through the probable cause conference. I will not say any more than that about what's alleged in terms of the facts at this time. This is a remand. Mr. Thurman is remanded to custody. In that case, there will be no bond. January 24th for the probable cause conference at 8:30 a.m. in front of Judge King. Preliminary examination, January 31st at 8:45 a.m. I'm sorry.
1:35. It's supposed to be for the exam.
At the time, you're telling me the time?
Yes.
Thank you. 1:35 p.m.?
Yes.
Thank you. Probable cause conference set for January 24th at 8:30 a.m. After that, preliminary examination set January 31st, 1:35 p.m. Both in front of Judge King. Thank you.
Thank you, Your Honor.
Hi, what's your name, please?
Anthony Valentine. Put your mask on, brother.
All right, Mr. Valentine. People, the Anthony Valentine Council.
Yes, Your Honor. Brandon Bird on behalf of Anthony Valentine. My client waived his right to the formal reading, was advised his constitutional rights, and will stay mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on Mr. Valentine's behalf, noting for the record, this is a non-assaultive allegation alleging possession of a weapon, but no assaultive use of that weapon. I do have a local address, no concern about flight, and nothing in the priors or any record to concern me about community safety. I don't have any priors listed here. $1,500 personal bond unless there's some objection.
No objections, Your Honor. Thank you.
Thank you. Sir, you're not to purchase or possess any firearms or other dangerous weapons during the course of this bond. The next court date will be January 24th at 8:30 a.m. in front of Judge Robbins for the probable cause conference. You'll have a preliminary examination date after that, January 31st at 8:45 a.m. Thank you.
Get the rest of them, Great. Great. Great.
Good morning. My name is Malcolm Thomas Taylor Hatchett.
All right, thank you. Good afternoon, Mr. Taylor Hatchett. People versus Malcolm Taylor Hatchett Council.
Yes, Your Honor. Brandon Bird on behalf of Malcolm Taylor Hatchett. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Thank you, counsel. Court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'm noting for the record, this is a non-assaultive allegation alleging possession of a weapon, but not the use of it in any assaultive capacity. Also, I do have a local address, no concern about flight, no priors that would concern me about community safety. This is going to be a $1,500 personal bond. Sir, you're not to purchase or possess any firearms or other dangerous weapons during the course of this bond. Probable cause conference will take place January 23rd in front of Judge Robbins at 8:30 a.m. After that, you have a preliminary examination date on January the 30th at 8:45 a.m. Thank you.
And is that preliminary exam gonna be in front of Judge Robbins too, Your Honor?
They don't give me that on the weekends. I'm sure they'll tell him on that day generally no. Generally, the prelim takes place in front of a different judge, but I don't know who it is yet.
All right, thank you, Your Honor.
Yep. How you doing? My name is Lenny Ricker.
One more time, please, a little louder.
My name is Otis Rucker, OTIS,
Oh, okay,
RUCK.
Mr. Rucker. Good afternoon, Mr. Rucker. Case is People versus Otis Rucker, counsel.
Yes, Your Honor. Brandon Bird on behalf of Otis Rucker. My client waives his right to perform a reading with advised his constitutional rights and will stay on mute.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Noting for the record, Mr. Rucker has no priors. Allegation here is non-assaultive possession of a weapon, but no assaultive allegations with respect to it. I don't see a danger to the community. I do have a local address. Nothing to tell me I should be concerned about flight. This will be a $1,500 personal bond unless there's some objection.
No objection, Your Honor. Thank you.
Thank you, Mr. Rucker. You are not to purchase or possess any firearms or other dangerous weapons during the course of this bond. The next court date will be the probable cause conference on January 23rd at 8:30 a.m. in front of Judge Robbins. After that, preliminary examination is scheduled for January the 30th. Thank you.
Come on, out this way. Oh, you done? Next man. You see what's better. What is that? Bullpen 6, like this way.
Hi, what's your name?
Sean Tyler.
All right, Mr. Tyler. People versus Sean Tyler, counsel.
Yes, Your Honor. Brandon Bird on behalf of Sean Tyler. My client waives his right to the formal reading, was advised his constitutional rights and will stay on mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I will hear your argument as to bond.
You give me one moment, Your Honor.
Y'all talk to the attorney, right? She said she didn't want to see him. She didn't want to see somebody go up. Okay, yes, sir.
Yes, Your Honor. My client indicates that he's a 21-year-old lifelong resident of Michigan, Your Honor. Lives with his father and stepmother. Indicates to us that he's never been in jail. He indicates to us that he's not on probation or parole and has no pending cases, Your Honor. Respectfully, he's laid off right now. It'd be difficult for him to pay a monetary bond at all. He's looking for a new job, but he's not going to be able to pay a monetary bond at all, Your Honor. And I understand the court may be concerned with flight, but he does have significant community ties, Your Honor. And respectfully, we ask this court potentially for a personal bond.
All right, main concern here is flight. There's nothing prior. I don't have an assaultive history here. I don't have concern about danger to the community, but he's alleged to have tried to run from the police after being found in and stole what I believe was a stolen vehicle, although they didn't charge that. Having run on foot, circled back to the car, jumped in the car and tried to drive it off. So I'm going to put him on a tether. He's going to have a very strict curfew cut off at 3 p.m. to make sure we're keeping track of him. We know exactly where he is. All right, I will do a personal bond though, because I don't really have any underlying allegations other than the running. $50,000 personal bond, GPS tether before he leaves the jail with a 3 p.m. curfew. Probable cause conference January 24th at 8:30 a.m. After that, preliminary examination January 31st at 8:45 a.m., both in front of Judge Archer. Thank you.
Thank you, Your Honor.
All right. What's your name, please? Sir, what's your name? I need you to speak up.
LaSharon Brown.
Thank you.
It's also known as Van Love.
Yes, thank you. All right, People versus Lasheron Brown, AKA Van Love. We've got a few different files here. We've got one with Judge Bryant where there's already a capias of $100, 10%. That one for retail fraud. Then I've got another in front of Judge Bryant. Is this one a capias or not?
They're both capias.
Okay, is there a capias amount attached to this file?
Yes, it's the same amount.
Same amount, $100, 10% on that file. Thank you. And then we've got a new file. That one is just an entering without owner's permission in a building. Then I've got a case in front of me from today, assault with intent to rob while armed, a habitual fourth notice, super have 25-year mandatory minimum notice here on this file. Counsel.
Yes, Your Honor. Brandon Bird on behalf of LaSharon Brown, aka Van Love, and my client waives his right to the formal reading, was advised his constitutional rights and will stand mute.
Thank you, counsel. The court notes formal reading has been waived, enters a not guilty plea on your client's behalf. In terms of bond, we'll take the easy ones first, which is going to be $100, 10% from Judge Bryant in both of those cases. While I may have the authority to reduce them to personal bonds, I am not going to do so. They will stay as is, as outlined in the capias. Now I will hear your argument as to the other case, please.
Yes, Your Honor. My client indicates to us that he's homeless. He has 3 children. He's homeless, unemployed. Any amount of bond is going to be like a remand to my client. I understand you're not changing the bond in the others, and I'm assuming we're going to get a bond on this case. So that probably would be the best thing anyway. But I did want to state that he needs a colostomy bag. He was missing. He needs a colostomy bag. Sometimes he has one, sometimes he doesn't. He spent a lot of the time in and out the hospital due to those matters. Actually, when he got arrested, that's when he was actually able to get a colostomy bag when they took him to the when they took him to the hospital, because he's been long homeless and he's been living a hard time in and out of shelters, trying to find shelter when he can. So, as I stated, any amount of bond would be like a remand to my client, Your Honor. Respectfully, I understand the assaultive nature of these allegations. And if it is going to be a bond, we're asking for low 10% bond seen fit by the court, which my client still wouldn't be able to afford. A tether, I'm not sure how much a tether would help in this moment, because he has nowhere to tether to. He doesn't have any home to tether to. And as I said, respectfully, we're asking for a low 10% bond seen fit by the court.
Thank you, DDC. Please mark this file medical. Charges in this last case are extremely assaultive. He's alleged to have approached the complainant twice, showed him a gun, then hit him multiple times with the gun, including inflicting a laceration to the forehead and knocking out his teeth. He was identified by the complainant, who is known to him. And I've also read that numerous members of the community came out and had to beg him to stop the assault. This is intended to act as a remand because remand is not available to me by statute here in this case or court rule. I am setting bond in the amount of $2 million cash. In the event that he's able to make that bond, he will be subject to a GPS tether before leaving the jail with full home confinement. Sir, you are not to purchase or possess any firearms or other dangerous weapons during the course of this bond. and you are to have no contact or attempted contact with the complainant, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be a violation of the conditions of the bond. Probable cause conference is set for January 23rd at 8:30 a.m. Preliminary examination is set for January 30th at 8:45 a.m., both in front of Judge Jefferson. Thank you.
Thank you, Your Honor.
Go back to the side, sir. Open the black line. Face the camera, Yacht. Say your whole name. Michael Edward Yacht.
All right, Mr. Yacht, People versus Michael Edward Yacht, counsel.
Yes, Your Honor. Brandon Bird on behalf of Michael Yacht. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Thank you, counsel. The court notes formal reading has been waived, enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
As to bond, Your Honor, my client indicates to us that he's a 46-year-old lifelong resident of Michigan, Your Honor. Indicates to us that he does have a prior criminal history, but it is all non-assaultive, Your Honor. You can give me 1 second. Prior criminal history is all non-assaultive, and his last incident seems to stem back to 2009. I understand this is an operating while intoxicated while third, driving while license suspended, which is serious and which is serious in nature, Your Honor. But respectfully, we're asking this court for a personal bond.
All right, thank you. This is a third offense, charged as a third offense, last offense being listed in 2009. What's the work situation?
The work situation, he works for a wholesale and a butcher. I know he starts work at 6 a.m. I'm not sure when is. If you could give me 1 moment, Your Honor.
Sure.
Okay, Your Honor. He does have to be working at 6 a.m. And if you just allow me to state a couple things. My client was arrested for this in 2020. He was released with no info about it, no future court date. It looks like the warrant was signed roughly 8 months later. 8 months later in this case. The defendant would have surrendered had he known about the warrant, but he hasn't moved since the incident date. He hasn't attempted to evade this issue. Actually, he's ready to put this matter behind him. He is due back at work at 6 a.m. tomorrow. I mean tomorrow. I'm not sure about his work hours, but as I said, he has 2 jobs, Your Honor. My client's not going to be a flight risk in this matter, Your Honor. He has 2 children. One of them young teen, and another one 11 years old, and lives with his wife and kids, who he's been supportive of all this time, Your Honor. So we're asking that you take a chance on my client and allow my client a personal bond in this matter.
All right. This is a third offense rising to the level of a felony. Because of the long period of time since the last one, I'm going to give him a personal bond, but I am going to require that he get an alcohol tether. And I understand that you're saying he has to be at work tomorrow, and we don't know if that'll happen if he has to get an alcohol tether, but this is a third offense. And I think I need to do everything in my power to make sure that while the case is pending, he's not out there operating while intoxicated. He's already driving without a license, because that's also charged. So, you know, I'm going to go ahead and require an alcohol tether. The next court date is gonna be January 23rd for probable cause conference. That one at 8:30 a.m. Preliminary examination set for January 30th at 8:45 a.m., both in front of Judge Sabri. Do we know which Sabri?
Aaliyah, they're all
Aaliyah.
Aaliyah.
Sabri. Okay, thank you.
Thank you, Your Honor.
All right.
What was the bond again, Your Honor?
I don't think so. 50,000 personal, alcohol tether before leaving the jail. No drinking, no driving.
Thank you, Your Honor.
Deviante Harris, good morning.
Good morning. All right, people versus Deviante Harris, counsel.
Yes, Your Honor. Brandon Bird, Deviante Harris.
Hold on, counsel.
Wait,
Hold on, counsel. Hold on. Let me try to deal with something. The volume is, I don't know. It's really unclear. Okay, go ahead and try again, please.
Yes, Your Honor. Brandon Bird on behalf of Deviante Harris. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I will hear your argument as to bond.
As to bond, Your Honor, 28-year-old lifelong resident of Michigan indicates to us that he lives with his mother and brothers, has two children, been gainfully employed the past 3.5 years now, but due to his family size, Your Honor, and his monthly expenses, he'll be unable to afford any bond in this matter, Your Honor. I understand these are very serious allegations and assaultive allegations. When my client looks for his day in court, he was arrested and released in December of 2022, stayed 3 days, stayed 72 hours, and was released on this matter. Would have turned himself in. He hasn't moved since. As I said, he has very stable employment, Your Honor, so he's not going to be a flight risk. And I understand these are serious allegations involving the officer, but they are allegations at this moment, as is why his court understands and looks forward to his day in court, and respectfully ask this court for a personal bond.
All right, thank you. One moment, please. What's our bond review hearing date now?
The 18th.
Thank you. All right, Mr. Harris is charged with 2 felonies. Assaulting, resisting, obstructing a police officer, causing injury, 2 counts of that, where he's alleged to have headbutted an officer in the face and some other things that are pretty concerning. I have no priors for him that I can see. I don't know whether there are any prior misdemeanor convictions. Is that information you have, counsel?
I don't have that information, Your Honor.
This started really as just a traffic stop and then trying to take him into custody on some traffic warrants, it looks like, if they were even taking him into custody. I'm gonna set bond in the amount of $50,000 cash surety due to concern for flight and community safety. If he's able to make the bond, he must be fitted with a GPS tether. All right. Is he working?
Yes, Your Honor.
Okay. What are the work hours? Well, I'll just make it okay to work. There will be a bond redetermination hearing, all right, where Judge Jefferson will look at this and see if she has a different opinion about the bond on January 18th, 2023 at 9:30 a.m. After that, probable cause conference is set for January 23rd at 8:30 a.m. and preliminary examination is scheduled for January 30th at 8:45 a.m. Again, all in front of Judge Jefferson. Thank you.
Black line, face the camera, say it forward now.
Giovanni Martin.
Okay, Mr. Martin, this is People versus Giovanni Martin Council.
Yes, Your Honor. Brandon Bird on behalf of Giovanni Martin. My client waives his right to formal reading, which violates his constitutional rights and will stand mute.
Thank you, counsel. Court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
Come on, Your Honor.
All right, counsel, I've taken a look at this. I mean, my concern was just given the charge, it was possession of a weapon in a jail, as it really looks like he was in a juvenile facility at the time. I was concerned whether there was some assaultive allegation there. There is not any assaultive allegation here in this case. So I don't have a concern about community safety. In terms of flight risk, I don't necessarily have anything that tells me I should be concerned about flight. Do you have community ties, and what are they?
Lives with his mother and brother, Your Honor. 18 years old, lives with his mother and brother, been here all his life, Your Honor.
What was he in the jail for?
That I'm not sure. And since it's a juvenile matter, well, YouTube, I'm not sure if I should go into that, Your Honor.
Fair enough, counsel. Is he working?
No, Your Honor. He's in high school.
All right. This is going to be a $40,000 personal bond. It's a personal bond, but I am going to put him on a GPS tether that allows him to go to school and to school only. I don't know what the nature of that prior is, but I'm, without knowing it, I feel like we just need to keep a little bit of control here. So the community stays safe and we don't have concerns about flight. So GPS tether, which will allow him to attend school, $40,000 personal bond, January 24th for probable cause conference at 8:30 a.m. Preliminary examination set for January 31st at 8:45 a.m. Both of these are going to be in front of Judge Aaliyah Sabri.
Thank you, Your Honor.
Thank you.
We gotta get that carjack and take care of too. Upstairs. Wait, what that? You got another. I'm still here?
Yeah. From the Black Line Station 9.
Sorry. Say your name. Kareem Walker.
Y'all speak up, sir.
DDC?
Kareem
DDC?
Walker. Yes.
Did you just tell Mr. Martin he has a carjacking case to take care of?
I'm not sure. That was outside the door. I didn't hear him.
All right, thank you. All right, I have not, for the record, been made aware of any other pending charges with respect to Mr. Martin. All right, what's your name, please?
Kareem Walker, Your Honor.
Thank you, Mr. Walker. All right, People versus Kareem Walker, counsel.
Yes, Your Honor. Brandon Bird on behalf of Kareem Walker, my client waives his right to formal reading, was advised his constitutional rights, so will stand mute.
Thank you, counsel. The court notes formal reading has been waived, enters a not guilty plea on your client's behalf, and I'll hear your argument as to bond.
As to bond, Your Honor, my client indicates to us that he's a 34-year-old lifelong resident of Michigan, Your Honor. 2 children, lives with his mother, Your Honor. He does have a criminal background. He is being charged as a habitual third, but I believe they are all non-assaultive, Your Honor. If you allow me to check just one more time.
Okay.
They are non-assaultive in nature. And it states that the last one was in 2010, his last conviction for attempt CCW, Your Honor. He is working for a shipping and receiving company, but he makes well below the property guidelines, even before we consider his family size. After his family size, he's very well below the property guidelines, Your Honor. And any amount of bond would be like a remand for my client. I understand the assaultive nature of these allegations, but my client does look for his day in court. And respectfully, Your Honor, we're asking this court potentially for a personal bond. Of course, not inclined to a personal bond, and a low 10% bond seemed fit by the court.
All right, I mean, according to the investigator's report, he at least basically confessed to hitting the complainant in the face here in this case. Okay, here, I'll quote from there. Here we go. There's all kinds of things about, don't worry about it. She's just a little bruised up because she's light skinned, nothing major. Getting into it with the officers about whether a dark skinned officer could understand the bruising that would have happened on her just from nothing major.
Officer, Your Honor, that was not.
Mr. Walker, this is your attorney speaking. Right now, the best thing that you can do is exercise your right to remain silent.
Yes.
Multiple quotes alleged to have been attributed to Mr. Walker, calling the officers soft ass niggas. He's going to whoop their asses. Vulgar comments about their genitalia. Saying the complainant was just a little fucked up in the face. Don't worry about it. Then she tries to escape into her mother's house. He's alleged to have broken in there while her mom was trying to get the door locked to protect her. If remand was available to me in this case, it's what I'd be doing. I have a lot of concern about complainant's safety, her mother's safety, community safety, and flight, given these alleged interactions at the time of being taken into custody. Bond is set in the amount of $750,000 cash. I do intend for it to act as a remand. I don't have that available to me through statute or court rule, so I am imposing a high cash bond. There is to be no contact with any of the complainants in this case. There is to be no contact with the address where this is alleged to have happened, either address where it's alleged to have happened. You're able to make that $750,000 cash bond. You will be subject, sir, to a GPS tether with full home confinement. Next court dates will be January 18th for bond redetermination hearing at 9:30 a.m. After that, probable cause conference set for January 24th at 8:30 a.m. and preliminary examination set January 31st at 8:45 a.m. All in front of Judge Aaliyah Sabri.
Can I speak, Your Honor, please?
The best thing you could do is not speak.
Your attorney is cautioning you. This is, of course, your bond hearing. He'll usually caution you not to ask questions outside of your bond or bond conditions because you are being recorded. Anything you say could and likely will be used against you in the future. I am not likely to change my mind because there are multiple witnesses here to this that intend to testify to these events. At least some scratching or bruising observed on the complainant's face. You're identified by a person or people known to you, so what that means is you're not likely to change my mind at this time, and you could say something that would hurt your case. You will have a bond review hearing in front of the judge who will be handling this the rest of the way, January 18th, and she will have more information to work with. So you may want to save your arguments as to your facts of your case to that time, or when you can further consult with an attorney and have them raise any arguments. But again, I'm not telling you you cannot speak because it is your right to do so, just as it is your right to remain silent.
Yeah, I just wanted to say, Your Honor, whatever occurred that night was not to that point. Me and her had a long night that night. We went out. It was my birthday weekend.
Sir, you're bordering on making admissions again. I would be very careful.
It wasn't what it's saying. What
Right.
saying in there.
Never mind. This is what I'm trying to explain to you, brother. There's nothing that you can do right now to change the bond. You explaining this issue. There's nothing we can do to drop this case. There's nothing that we can do to drop a charge at this moment. You are going to have a redetermination hearing on the 18th, and we could go more in depth with it at that time. Then you're going to proceed with another lawyer. You're going to be able to go to bond again. I mean, address bond again. But right now, the only thing you could do is hurt yourself.
Okay, I'm sorry. No.
All right, thank you. DDC, before I leave the male side, I am sure that as Mr. Martin was walking away, I heard him say, "So I'm out of here," or something to that effect, and someone else say, "You still have the carjacking to deal with." Are you telling me that was not a member of DDC staff who mentioned a carjacking, and was it with respect to Mr. Martin?
If it was, Your Honor, I didn't have privy to the conversation because the bullpen is right behind us. So anybody could have said that. I just don't know who said it.
Can you please inquire of the staff that might be around you as I go to the female side on camera 2, whether it was a DD staff member that referenced a carjacking with respect to Mr. Martin?
I can do that as soon as he gets back.
Oh.
Or I can go.
Okay, thank you. I understand that you've got to maintain, staffing levels and all that you've got going on over there. So, but it is important to me. I'd like to be working with as much information as I can. And I'm pretty sure I heard him say, "So I'm not out of here," because someone else said something about a carjacking. And I want to know. All right, going to the female side.
Okay.
Hi, what's your name, please?
Sierra Boyd.
Okay. People versus Sierra Boyd, counsel. Are you muted? You're muted, counsel.
Sorry about that, yeah. Brandon Bird on behalf of Sierra Boyd. My client waives her right to the formal reading, was advised to constitutional rights, and will stand mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I will hear your argument as to bond, noting for the record, though, that this is non-assaultive. I see no priors. I don't have a concern for community safety. I've got a local address, nothing to say I should be concerned about flight. So tell me what else you'd like me to know about bond.
Your Honor, I believe you summed it all up.
Okay.
24 years old, lifelong resident of Michigan, lives with father. Works for 2 delivery services, but still below 200% poverty guideline. She was arrested and released on this in October of 2022. Didn't know the warrant was issued or would have turned herself in, Your Honor. Respectfully, we're asking this court for a personal bond.
All right, thank you. Noting for the record that the firearm she was in possession of or alleged to have been in possession of is registered to her. And noting that no round was chambered in that firearm, and she seemed to be under the incorrect impression that she was open carrying, which would have been allowed under Michigan law had she actually been open carrying. But she had not. It's very difficult to do in a vehicle here. So she wasn't technically open carrying. But I will give a personal bond here, $1,500. Next court date is going to be the probable cause conference on January 24th at 8:30 a.m. After that, preliminary examination, January 31st at 8:45 a.m. Both of those are going to be in front of Judge Aaliyah Sabri. I'm sorry, hold on. This should be a Judge Robbins case first, right? It's a plain CCW, but it is. You want to take a look at it? Hold on one second. Let's make sure we got the right judge.
Got you, Your Honor.
Yes, should be, Judge Robbins, but same dates.
Okay, very good. Let me have that back because I don't remember what they were. Sorry.
No, that's fine.
Thank you. Okay, so the first court date is going to be in front of Judge Robbins, January 24th at 8:30 a.m. And then they'll tell her at that time. They'll tell you at that time, ma'am, who the judge is for your January 31st date if it becomes, if you go forward to preliminary examination. All right, $1,500 personal, not to purchase or possess any firearms or other dangerous weapons during the course of this bond.
All right.
Thank you, Your Honor.
Thank you. Thank you. Mr. Bird, I'm going to hop back over there to the male side. I don't know what's going on with Mr. Martin, but I'm going to try to get it figured out.
All right, no problem, Your Honor. If I find something out, I'll let you know.
Okay, thanks. Hey, DDC, I'm back on the male side. Do you have any more information on Mr. Martin?
Yes, ma'am. I looked at his DIS sheet and it has a what he came in on was for a robbery carjacking. He has not been charged with that as of he got arrested for that yesterday when he came in. So that hasn't been adjudicated yet.
Okay, and so we're not risking him timing out or anything on that case. That case, he'll be held there until the warrant is submitted on that case. If it's submitted in the next 48 hours, he'll still be there and be arraigned on that warrant. Is that correct? If it's approved?
That's correct.
Okay, all right.
Yes, that's the reason he got. That's the reason he was arrested, and the old charge came up.
None of that is listed in this investigator's report that came to me. Can you bring him back, please?
What's his last name, Your Honor?
Giovanni Martin. No, that's okay, DDC. If I don't have any risk that he's going to time out and you're going to hold him the 48 hours to see if that is a warrant is approved, then we'll leave bond as is. I don't think I should be considering things that he's not even charged with at this time. He's just suspected of. Okay, so we'll leave bond as it is set. You guys have a good night.
Thank you for the time.
Thank you. Bye-bye. All right, Mr. Bird and Ms. Stevenson, you guys have a good night.
Thank you. You too.
All right, bye-bye.